Application for unauthorized cultivation, regularization. 2020.
The connected matter is not the next adjacent land, where it is also unauthorized occupation. This honorable court has granted passed an order for grant of reading order. Adjacent land.
By which order?
29/8/2023. The interaction is directed that there should be no felling of trees in the land bearing survey number 34, Malampalli, Delmanka, Srinivasapura, and Kola. This land is adjacent, survey number 35. Where we are.
Just because it is adjacent, it will not make a similar case.
Because in that particular land also.
Please tell us, sir, what is the issue? You are saying that trespass by the third and fourth respondent into your property. Then you'll have to go to the civil court.
Without issuing any notice, they have actually trespassed into the land, and they are.
Who has trespassed?
The third and fourth respondent.
Who are they? Private.
Forest office. No.
Huh?
They are forest office.
No.
Deputy Commissioner and Chief Conservator of Forest.
Trespassed.
What
do you mean trespass?
Forest lands. They claim that these are all forest lands. But I am an unauthorized document.
What have they done now? What have they done?
No, they are trying to fence the particular portion of the land and fell the trees. The trees or the plantations which I have grown, that mango crop and other things that they are felling the mango crop. Therefore, I am seeking for an order sparing them from issuing a notice. We let them issue notice, we will answer to that notice. And based on that, we will let them take things. Sarkari Karav and the article column number 10, there is already a notification. Year 50/51, where is that notified as fire threat. What is the next 2 page 50? Column number 10. Steel class state forest PO. 51/52 2015. So the lands to the extent of 322 acres and already been classified as state forest. Now, they are saying that they were not making issue and this land they were unauthorized cultivating this land.
Your names are not found in the RTC.
The extent of land.
Yaro Shataj Begum.
Sagumadi chit has been issued with my name.
It is not found in the RTC.
RTC has been applied. Still it is pending. RTC process is pending. In the meanwhile, having unauthorized document, having to stay in position, if any decision that they take, let them take a decision after issuing notice. That's the summary.
Who is this Shataj Begum? Whose name is found in the RTC? That is only in respect of 3 acres. There are totally 351 acres.
Yes.
2005, 2006. Where is it? Annexure J. Annexure J.
Okay, the day, oh, right. '41. My name is shown.
Learned AGA. Takes notice for all the respondents. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. Learned counsel for the petitioner submits that there are at least 5 other petitions pending consideration before this court in respect of the adjacent lands. All the survey number
Number 34.
35.
35.
35 of Malampalli village, Nelavanki Hobli, Srinivaspura Taluk. Stop. It is submitted that in writ petition number 19171 of 2023, this court issued interim directions by order dated 29/8/2023, directing the respondents not to fell the trees in the land in question until further orders, and the same has been extended from time to time. Stop. Statement of objections have been filed in some of the matters, and the submissions of the learned additional advocate general have been noticed in the daily orders passed by this court. Stop. Learned counsel press for similar directions. Stop. Okay. Please see this order sheet. Your AAG has made submissions.
That is not been related to this particular land.
Same survey number.
The second round of repetition.
Ah.
The round of repetition is the five. The order was put and before they implement your repetition. Because they made ATV clear. There's two ones. I made in the second one. Earlier I saw filed an expedition.
Ah.
Same petition.
Huh?
Same petition.
Ah.
The relief was, they said, when there is action, then you come to this one.
Declaring that petitioners are entitled to cultivate and occupy the lands. Direction to restrain third and fourth respondent from declaring the lands in question as forest lands, pending consideration of the petitioner's application for grant of occupancy rights.
Now page 30 of the petition, they really have.
What happened after this order was passed?
After this order was passed, no action was taken. Subsequently, they came forward to take action not only in respect of my land, but even the adjacent land. That is being surveyed. Therefore, I came before this one.
And really what they are asking, the same, page 13. Page 13 of the petition.
No, but what action did you take after this order was passed?
But they are, my lord, they filed a petition for the court when it's order of court, saying that declare that they are in possession and occupied.
Right.
If my lord, page number 13 of the petition.
Ah.
They believe they are part.
Allah, aito. What did the authorities do after this order was passed? So therefore it was directed, if they take action in accordance with law.
Let them appeal.
Yes.
Now, believe what they have fought in the page 13 of the same thing. There is not even a single thing of it. They believe they have fought. Unless there is a notice that has been issued, or if there is any.
Therefore, if the direction is given not to fell the trees, what is the problem? There is an apprehension that you are cutting the trees. So it's only directed not to fell the trees. Ashte, nothing more. However, learned AGA points out to a previous round of litigation in WP number 8066 of 2023, which was filed at the hands of the petitioner's hearing. So, learned AGA submits the very same prayer that was made earlier has been made in this petition also. So, next para. The petitioners have not concealed the fact that they had filed the writ petition earlier, and they have furnished a copy of the order dated 20th of April 2023 at Annexure U. Full stop. Next para. Consequently, the respondent authorities are directed not to cut the trees. In survey number 34 of Mallampalli, same, 35. 35. Nimdu 35, without there being specific directions from this court. Yes. List this matter along with the WP number 19171 of 2023. ಏನ್ ಮಾಡಿದಾರೆ annexure C ಅಲ್ಲಿ?
Particular property has been notified as a home property. So, the home property is not state like the rate. For the DP does not have what 48. 48. For the ಜಿಲ್ಲಾ ಅಧಿಕಾರಿ ಜಿಲ್ಲಾ ಪ್ಯಾಕೇಜ್ ಇಪ್ಪಡಾಪುರವರು ತಮ್ಮ ಪತ್ರದಲ್ಲಿ ತಿಳಿಸಿದಂತೆ ಮಾನ್ಯ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಧೀಶರಂತೆ ಒಬ್ಬರಿಗೆ ವರ್ಷ ಹಾಗೂ ಈ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ಒಕ್ಕೂಟದಿಂದ ಆದಿಸೂಚನೆ ಮತ್ತು ಸಂಧಾನ ಮಾಡಿದ ನಂತರ ಸದರಿ ವಸ್ತುಗಳು ಸಂಬಂಧಿಸಿದಂತೆ ತೀರ್ಮಾನ ಕೈಗೊಳ್ಳುವ ಅಧಿಕಾರದಲ್ಲಿ ಈ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಇರುವುದಿಲ್ಲ. ಪ್ರತಿಯೊಂದು ಉಪವಿಭಾಗಾಧಿಕಾರಿಗಳ ಉಪವಿಭಾಗ ಆದೇಶ ಸದ್ಯ ಪ್ರಸ್ತುತವಲ್ಲವೆಂಬುದಾಗಿ ಕೇಂದ್ರ ಆದೇಶ ಮಾಡುತ್ತದೆ.
ಅದಕ್ಕೆ ಮೊದಲು ಅವರು ಸಿಂಗಲ್ ಪೀಸ್ ಆಫ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರೋದು ಇದು ಒರಿಜಿನಲಿ ಬಿಲಾಂಗ್ ಟು ಮೈ ಫಾದರ್.
Sir, the deputy commissioner cannot go into all those aspects because admittedly the land is notified.
No,
Huh?
ಯಾವ್ದು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ. ಎಕ್ಸೆಪ್ಟ್ ಇದು ಬರ್ತಾ ನೋ ಸಿಂಗಲ್ ಪೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್, ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ, ಸರ್ವೆ ರಿಪೋರ್ಟ್ ಇಲ್ಲ, ಯಾವಿಲ್ಲ, ಗೆಜೆಟ್ ನೋಟಿಫಿಕೇಶನ್ ಇಲ್ಲ. ಇವಾಗ ವಾಚಿಂಗ್ ಪೇಜ್ ನಂಬರ್ 45 ಇಂದ ಪ್ರಸ್ತುತ ಕೆಳಗಡೆ ದಾಖಲಾಗಿ ಪರಿಶೀಲಿಸಿ ಪರಾಮರ್ಶಲಾಗಿದೆ. ಅಲ್ಲಿ ನೋಡಿದ್ರೆ ನಮ್ಮದೇ ಪೇಂಟಿಂಗ್ ಅಲ್ಲಿ ಇರ್ತಾರೆ. 2000 ಏನಾಗ್ತದೆ ಅಂದ್ರೆ ಆರ್ಟಿಫಿಷಿಯಲ್ ಮ್ಯೂಟೇಷನ್ ಮಾಡೋದು ಬೇರೆಯವ್ರ ನಮ್ಮ ಆರ್ಟಿಫಿಷಿಯಲ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ದಾರೆ.
Please see paragraph number 8, page number 46 in that order. They have mentioned the notification date. Please see, sir. Paragraph number 8, ಕೆಳಗಡೆ last 3 lines. ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 48/1ರಲ್ಲಿ 3 ಎಕರೆ ಜಮೀನನ್ನು ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕ್ಫ್ ಬೋರ್ಡ್ ಬೆಂಗಳೂರು ಅವರು ನೋಂದಣಿ ಪತ್ರ ಸೋ ಅಂಡ್ ಸೋ 2001 ರಂತೆ 14/11/2000 ವಕ್ಫ್ ಆಸ್ತಿಗೆ ಒಳಪಟ್ಟು ಹಜರತ್ ಕಮಾಲುದ್ದೀನ್ ಖಾದ್ರಿಯ ಖಬರಸ್ತಾನ್ ಎಂದು ನಮೂದಾಗಿರುತ್ತದೆ.
ಎಲ್ಲ ಅಂಶ ಇಲ್ಲ. ವಿವಾದ ಜಮೀನು ಮೂಲಕ ವಾದಿಗಳ ಪೂರ್ವಜರೆಂದು ಬುಕಾರಿ ಸಾಬ್ ಅವರ ಹೆಸರಿಗೆ 1966ನೇ ಸಾಲಿನಿಂದ 1992ನೇ ಸಾಲಿನವರೆಗೆ ಅವರ ಹೆಸರಿಗೆ ವಿವಾದ ಜಮೀನಿನ ಖಾತೆ ಬಂದಿದ್ದು ಪಟ್ಟಿಯಲ್ಲಿ ಪಿತಾರ್ಜಿತವಾಗಿ ಬಂದಿರುವ ಬಗ್ಗೆ ನಂತರ 1998 ಸಾಲ ಪೌತಿ ವಾದಿಸು ಮೂಲಕ ಅವರ ಮಕ್ಕಳು ಸಂಬಂಧಿಗಳು ಮತ್ತು ತಮ್ಮನ ಮಕ್ಕಳಿಗೆ ವಿವಾದ ಜಮೀನು ಬಂದಿರುವುದು ಕಂಡು ಬಂದಿದ್ದು ಪಾರ್ಟಿಷನ್ ದಿನಾಂಕ 26/9/2000ರಲ್ಲಿ ಸೈಯದ್ ನೂರುಲ್ಲಾ ಹಸನ್ ಹುಸೇನ್ ಬಿನ್ ಸೈಯದ್ ಅಹಮದ್ ಅವರು ವಿವಾದ ಜಮೀನನ್ನು ಜಿಲ್ಲಾ ಕಮಿಟಿ ಅಧಿಕಾರಿಯವರಿಗೆ ಖಬರ್ಸ್ತಾನ್ ಅರೇಬಿಕ್ ಮದರಸೆ ಮಾಡುವ ಸಲುವಾಗಿ ದಾನ ನೀಡಿದರು. ಅವರಿಗೆ ಪ್ರಾಪರ್ಟಿ.
So therefore, what he is saying is, once it is notified, the deputy commissioner will have no jurisdiction. You will have to go before the waqf board. That is the direction. Please go before the waqf board. He has not decided the case, sir. He has only said, I will not get jurisdiction.
Even illegal mutation without any document.
He will not get jurisdiction to consider that. Because it has been notified, whether you like it or not. It has been notified as a waqf in the note.
ಅಲ್ಲಿ ಬರ್ತಿದ್ದಾರೆ ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ, ಯಾವುದೇ ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ. ಅವರು ಒಂದು ಲೆಟರ್ ಕೊಡ್ತಾರೆ, ಲೆಟರ್ ಬೇಸಿಸ್ ಮೇಲೆ ಅದನ್ನ ಎಂಟ್ರಿ ಮಾಡ್ತಾರೆ. ನೋ ಸಿಂಗಲ್ ಪೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್.
Recorded.
ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್ ಮುಂದೆ ಅವರು ಒಂದು ಲೆಟರ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ತಾರೆ. ಹೀಗೆ ಆಗಿದೆ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲಿ. ನೋ ಸಿಂಗಲ್ ಪೀಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್.
Perfect. Learned AGA takes notice for response number 1 to 3. Learned counsel Shri Mali Patil. Enta Mali Patil? T.S. Mali Patil. T.S. Mali Patil is requested to take notice for response number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned AGA and learned counsel for response number 4. Next para. The contention of the petitioner, learned counsel for petitioner, that in the impugned order, the deputy commissioner has only recorded a communication made by the district waqf officer that the land has been notified as a waqf, copy of the notification has never been produced. Full stop. It is the contention of the petitioners that no such notification has been issued. Full stop. Next para. Learned counsel for response number 4 is required to furnish a copy of the notification which has been discussed in paragraph number 8 of the impugned order passed by the deputy commissioner. Release this matter on 20th of February. Our ಇವತ್ತೆ ಕಾಪಿ ಕೊಡಿ. ಇಲ್ಲ ಆನ್ಲೈನ್ ಹಾಕ್ಬೇಕಪ್ಪ. Please file it. It will be done within 2 months if you do it. Yes, disposed of. Huh? Hmm. 35.
But SSC, the order of the Tashila. The case of the petitioner,
Hmm.
the land is of 5 acres, 5 surrender 107. The new surrender 252 was granted in the land petitioner, whereas in their 1940. And thereafter the podium grew to a
Petitioner.
with the
Grandfather. Ah.
whereas in their 1940.
Ah.
Thereafter, as per the order of the Tashila itself, stated that the land has the new surrender as a trade as a surrender 252 as a fund. Then 1846 itself, thereafter the land traditional was in possession, and in the meanwhile, the Ministry of Roadway has acquired the land, portion of the land, measuring 9090 square meters, which is at page number 75. Page number 75. The Ministry of Road Transport and Highways. Portion of the land, number 250, page number 75.
Page number 75 only.
Survey number 252, column number 5.
Ah.
The name of grandfather of the petitioner, namely Muniappa.
Ah.
Portion of the land is 9090 square meters, approximately below 2 acres, 8 or 9 or 10 meters.
Ah.
What happened, bro? So in the meanwhile, respondent number 11, the respondent number 11 filed an application before Tashildar requesting to transfer of property in his name based on inheritance. So Tashildar registered the case in order to issue and 450 for 1780 and hold at page number 41, the reason portion by December. Page number 41, paragraph.
Yes.
ಏನಂದ್ರೆ ಉಪಯೋಗಗಳು ಸಲ್ಲಿಸಿಕೊಂಡಿರುವ ದಾಖಲೆಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ವಾದಿ ಮತ್ತು ಪ್ರತಿವಾದಿಗಳು ತಮ್ಮಲ್ಲಿ ಲಭ್ಯವಿರುವ ಮಾಹಿತಿ ಹಾಗೂ ದಾಖಲೆಗಳಲ್ಲಿ ಅಧಿಕಾರಿಗಳ ಮುಖ್ಯಪ್ಪ ತಮ್ಮ ತಂದೆಯವರ ದಾಖಲೆಗಳು ಅವರು ಮಾತ್ರ ಅವರ ವಾರದಾರರನ್ನು ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಈ ಸಂಬಂಧ ವಂಶಾಂಶಗಳನ್ನು ಸಲ್ಲಿಸಿಕೊಂಡಿದ್ದಾರೆ ಹಾಗೂ ವಾದಿಯವರು ಎರಡೆರಡು ರೀತಿಯ ವಂಶಾಂಶಗಳನ್ನು ನೀಡಿದ್ದಾರೆ ತಿಳಿಸಿಕೊಂಡಿದ್ದಾರೆ. ಉಭಯರು ಸಲ್ಲಿಸಿಕೊಳ್ಳುವ ವಂಶಾಂಶಗಳಲ್ಲಿ ಖಾತೆದಾರರೊಂದಿಗೆ ಮೂಲ ಸುಭಾಷಗಳನ್ನಾಗಿಸಿ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಅವರ ಹಿಂದಿನ ತಲೆಮಾರಿನ ವಿವರ ತಿಳಿಸಿಲ್ಲ.
Therefore, both of you are claiming under the same person.
Both are claiming based on
Therefore,
the Tashildar does not represent the Kata either in the name of 11th respondent or in the name of petitioner. In the interest in the Kata has been recorded in the name of respondent number 5. There is no reason at all.
who are they?
The last paragraph, page number 43. The respondent number 5 says we are not disputing their title and ownership.
Who are they?
They are the 12 parties. They are the owners in respect of cell number 107 but P3 and P4. We are not disputing the right title and impact of
In terms of the genealogical tree produced by you and that Panduranga, these people are not members of the family.
They are not the parties before the Tashildar, either before the district.
Aye.
So the last pair of the.
Aye. Next.
What happened? Thereafter, we have filed the.
You went before the assistant commissioner.
Yes. Also dismissed the appeal.
Ah.
Noting that not surrender number 252 and surrender number 107 by P3 and P4 are one and the same. In order to avoid confusion, directed the Tashildar to delete survey number 107 by P2, re-survey 252, and directed the Tashildar to record the name of the respondent number 5 and the record.
But then your contention, what happened to your contention? that they are not the members of the
They
family.
are not members of our family, but
Ah.
they are purchasers.
How that contention has been considered?
They are not made any objections or document before the Tahsil or not. The Tahsil himself.
Have you not contended before the Assistant Commissioner? Even if that is so, these persons are not members of the family according to the genealogical tree produced by that person and myself. How can the name of these persons be entered?
Based on the same.
Tahsildar Ayatri, Assistant Commissioner.
Based on the savings.
ಯಾವ sale deed?
The sale of the respondent was particularly.
They have purchased.
Please, sir.
ಮತ್ತೆ
They purchasers from Vanshi Munyappa son of Vidaya.
ಏನ್ ಮಾಡಕ?
They are not disputing the right and taken law.
Hmm.
They are purchasers Vanshi Munyappa son of Vidaya. We are the sons of Munyappa son of Timaya. The artist is the reason.
That is not important, sir. If their names have been entered consequent to a registered document, we cannot.
We are also.
We will have to go to the court. Civil.
Civil suit is filed.
Let it be decided. Let it be decided.
Civil suit is also filed.
ಯಾವ್ದ್ರಲ್ಲಿ?
Before the serious immediate.
Let it be decided.
File. And say petition has also been taken before the technical. We are not disputing the ownership of the referendum political. We are also owners. So,
Sir, that has to be decided by the civil court now.
the date is also produced.
ಅವರು ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ OS 373 of 2019.
Page number 129. Both extents are there, no? When Kaili see the artist, the recent artist. The artist is at page number 89.
When did the Tahsildar pass the law?
Amalgamation, ಅದನ್ನ ಸರ್ಕಾರೀಕರಣವನ್ನು ತೋರಿಸಿ. Both are owners, our property, our own is the property now own is.
2018. The Tahsildar passed the order in the year 2018.
Page number 89 after the order.
Huh?
Page number 89.
Prior to this order passed by the Tahsildar, whose name was found in the.
So with respect to the survey number 107 for P3 and P4, the respondent was 5 to 10 below. The survey number 252 the petition. The grant of the petition. There is no dispute over the lands in question. For another point, confusion at the survey number 107 for P3 but 107 for P3. And the property of survey number 252 one day you illa ante ಹೇಳ್ತಾರೆ ಇಲ್ಲ. So before passing of the order by the Tahsildar and Assistant Commissioner, the record of rights in the name of referendum number 5 there as well as the grant of the petition. Okay, but amalgamation ಮಾಡಿ page number 89 ಅಲ್ಲಿ ಅವರ ಹೆಸರಿಗೆ ಆರ್ಟಿಕಲ್ ಕೊಡ್ಸಿ ನಮ್ಮನ್ನ ಸರ್ಕಾರಿ ಕಾಲವಾಗಿದೆ ತೋರಿಸಿ. So recent article for that 22.
Page number
89.
80?
89. Related articles. ಸರ್ಕಾರಿ ಕಾಲವಾಗಿದೆ 71 acres 14 ಇದು ಅಮಾಲ್ಗಮೇಷನ್ ಮಾಡಿ ಇರೋದು
71 acres.
71 acres 14 ಗುಂಟಾಸ್ ಸರ್ಕಾರಿ ಕಾಲವಾಗಿದೆ ಇನ್ನೊಂದು 28 acres 3 ಗುಂಟಾಸ್ ಇವರನ್ನ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಪೇಜ್ ಬಂದ್ರು ಸ್ಟೇಟ್ ಹರೀಶ್ ರಾವ್ ಮಾಡಿದ್ರು ಅವರ ಎಕ್ಸ್ಟೆನ್ಷನ್ ನಮ್ಮನ್ನ ಸರ್ಕಾರಿ ಕಾಲವಾಗಿದೆ ಇವಾಗ ಒಂದು ಸರಿ ನಂಬರ್ 107 ನೋಡ್ಬಿಟ್ಟು 107 ಬರ್ತಿದ್ರೆ ಆ 107 P4.
It is not correct. If there are so much other extent of land and their name was continued till the order was passed in the year 2018 by the Tahsildar, how could their names be removed?
The respondent number 5 are not claiming our property.
Adene. If there are two separate properties,
And the properties are very much available in this part. We are in possession of the same. They are also in possession.
now you also filed a suit against whom?
Saying that the referendum number 5
Saying what?
we are the new owners in respect of number 252.
And they have filed return statement?
They already granted.
ಅಲ್ಲ ಅದಕ್ಕೇನೆ there was no need at all. ಬರ್ಲಿ Nodi, though they were not even parties to the proceedings, the Tahsildar passes such an order. Huh? Then AGA takes notice for response number 1 to 4. Yaro? Aurilla. Issue notice to response number 5 to 13. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Text para. Learned counsel for the petitioner submits that at the instance of respondent number 11, Sri M. Panduranga. Proceedings were initiated by the special Tahsildar, by the Tahsildar, Ramnagar Taluk, in RRT bracket this close 450 of 2017-18 against the petitioner and ಅವರಿಬ್ರು ಯಾರು ನವೀನ್ ಮತ್ತೆ who are they?
Their private party, they also filed a petition for their private party, they are not related to the family of the petition.
And the respondents number 13 and 14. 12 and 13. Stop. The claim of the 11th respondent hearing before the Tahsildar was that in terms of the genealogical tree furnished by him, he is the legal heir of the original grantee, Sri Muniyappa, who was granted 5 acres and 5 guntas in survey number 252 of Hallimala village, Kasaba Hobli, Ramnagar Taluk. And therefore, he sought for entry of his name in the land records. Stop. The petitioner also claimed to be the legal heir of Sri Muniyappa. Stop. However, the Tahsildar passed an order on 24/9/2018 directing entry of the names of respondents number 5 to 10. Although there was no claim made by them, and in terms of the land records, they claim to be the owners of another piece of property through Yaro. On the strength of a registered sale deed. Stop. Then a council submits that the assistant commissioner as well as the deputy commissioner have not understood the contention of the petitioners in the right perspective, and as a consequence of which the petitioner was constrained to file a suit in OS number 373 of 2019 seeking a declaration of rights in respect of the land in question. Stop. Learned counsel submits that the claim of response number 5 to 10 under a registered sale deed is not in respect of the property which the petitioner as well as respondent number 11 are claiming. Full stop. The learned counsel would further submit that as a consequence of the impugned orders, the name of the original grantee, Sri Muniappa, has been removed from the RTC and the name of government is now shown in the same place while retaining the name of respondents number 5 to 10 in respect of another piece of property. Full stop. Next paragraph. Consequently, there shall be an ad interim order of stay of the impugned orders at annexures A, B, and C till the next date of hearing. Stop. The Tahsildar, Ramnagar Taluk, is directed to restore the name of Sri Muniappa in the land records as it was. Huh? As it was prior to the orders passed by the Tahsildar on 24/9/2018. Stop. Action shall be taken by the Tahsildar by the next date of hearing. Full stop. Release this matter on 27th of February.
Yes, other was very was very grand, 100 kind of non-lands. Because granted, it contains of the application, the guidance, the person was granted, application was granted, the occupation rate was connected here, that is was on 1979. That premium amount has also been paid. Definitely, 20 quintas, each 260.
Occupancy rights were granted in favor of Kariyappa. Huh? Hmm. ಎಲ್ಲಿದೆ ರೀ ಅನಕ್ಷರ ಅಲ್ಲಿ ಇಲ್ಲಲ್ಲ ಆತರ ಕೇಶವಮೂರ್ತಿ ಕೇಶವಮೂರ್ತಿ ಹಾ only 10 guntas 10 plus 10 ah
and premium amount has also been paid through channels. There is no dispute about it. Subsequently, what the petitioners have made series of applications to the seeking to change the Kaka as per the order passed by the special deputy. Till date, no action has been taken. In some portion of this land, it comes within the government in the they are affected with this in small extent. Remaining extent no action taken either by the private municipal council or by the area. There are a number of representatives no action taken. Now, great word and enforcement activity issue by the
ಯಾವ್ದು ಅಲ್ಲೇ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟರು ಯಾರೋ ಕೆ ರಂಗನಾಥ್ ಅನ್ಬಿಟ್ಟು K. Ranganath. Why he is not a party to this proceeding?
But in this and also as a party, made a party, and also as a representing other petitioners as well as the others. And understanding issued by the
petitioner number 5.
Yes.
ಅವರೇನಾ ಬಿ ಕೆ ರಂಗನಾಥ ಬಿ ಕೆ ರಂಗನಾಥ್ ಇಲ್ಲೆಲ್ಲ ಕೆ ರಂಗನಾಥ್ ಅಂತ ಇದೆ ಬಿ ಕೆ ರಂಗನಾಥ್ ಸೇಮ್ ಪರ್ಸನ್ ಹಾ ಹಾ ಹ್ಮ್
Second,
Yes.
non-alienation petition ಕಸದ ಹೋಬಳಿ ಬೇಡು ಗ್ರಾಮದ ಸದನ 214/2 ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖಿಸದಂತೆ ಮೂಲ ಮಂಜೂರಾತಿ ಪಡೆದ ಕಚೇರಿಯಲ್ಲಿ ಲಭ್ಯ ಇದ್ದಲ್ಲಿ ಮೇಲ್ಮನೆ ಸಲ್ಲಿಸುವ ಬಗ್ಗೆ ಇಬ್ಬರನ್ನು ಉಲ್ಲೇಖದಂತೆ ಸೂಚಿಸಿದ್ದು ಅದರಂತೆ ಸಚಿವ ಪ್ರಾಧಿಕಾರದ ಮೇಲಿನನ್ನು ಸಲ್ಲಿಸಿ ಸೂಕ್ತ ಪರಿಹಾರ ನೀಡಬೇಕಾಗುತ್ತದೆ. ರೆಕಾರ್ಡ್ ಹೋಗಿದ್ರೆ ಹೇಳಿಲ್ಲ, ಸುಮ್ಮನೆ ಎಂಗೇಜ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ಸ್ ಆರ್ ದೇರ್. Granted the occupancy data of this Keshavmurthy and then for the record to show that the land was granted under the Innovation Act. Our end efforts actually working that. In the other yes, under the after letter of the Assistant Commissioner, it is mentioned in the reference on the annexed deed. Our approximate institution understand. We didn't make any effort to search the record and to take action for change of plan. Simply issues understand. As records are there, to show that we are in granted occupancy. We are in possession also. There are no relevant claims. My opinion is that.
It is public is written indicated. The order of their legal order.
ಎಲ್ಲ ಹಿಂಗೆ ಆಗೋಯ್ತಲ್ರಿ.
Records ಇದ್ದಲ್ಲಿ ಲಭ್ಯವಿದೆ.
ನಾವ್ ಆಮೇಲೆ ರೆಕಾರ್ಡ್ ತರ್ಸಿದ್ರೆ ಅಲ್ಲಿ ಬೇರೆ ಇರುತ್ತೆ. Why I don't know why people are being harassed like this. Learned AGA. ಇವ್ರು ಏನಕ್ಕೆ ಟೌನ್ ಮುನ್ಸಿಪಲ್ ಕೌನ್ಸಿಲ್? So?
Some portion is the tax.
How are we concerned with them in this petition? Your prayer is a direction to the revenue authorities to enter your name in the land records. Why have you made them a party here?
Some portion is there, some portion is
Maybe you can't issue direction to respond number 5. Then why have you implemented it here? ಏನ್ರಿ ಅರ್ಥನೇ ಆಗಲ್ವಲ್ರಿ. We are not concerned with the local bodies jurisdiction. It has been made.
Letter 26.50 into 20 and 10.5 into 60. 3/4. There are houses also.
Issue notice to respond number 5. Learned counsel for petitioner is directed to serve a copy of the petition along with annexures on the learned AGA. Stop. Next para. It is the contention of the petitioners that Sri Keshavmurthy, the husband of petitioner number 1 and father of petitioners number 2 to
Brothers, 2 to 5 are sons of that was not in the name of Keshavmurthy was the eldest son.
the contention of the petitioners that although a claim petition was filed by Sri Kariyappa seeking conferment of occupancy rights in respect of 20 guntas of land in survey number 216 of Belur village. Belur village, Kasba Hobli, Belur Taluk, Hassan district. the Special Deputy Commissioner for Inam's abolition passed an order on 22/1/1979 conferring occupancy rights in favor of one of the sons of Sri Kariyappa, namely Sri Keshavamurthy. Stop. Petitioner number 1 is the wife of Keshavamurthy, and petitioners number 2 to 5 are the other sons of Sri Kariyappa. Full stop. Their grievance is that in spite of payment of the premium, the name of the grantee has not been entered in the land records. Stop. In this regard, the petitioners, through the 5th petitioner, gave several representations to the revenue authorities to enter the name of the petitioners in the land records. Full stop. However, the Tahsildar has issued the impugned endorsement dated 26/6/2023, stating that the original records are not available, and therefore the names of the petitioners cannot be entered in the land records. So, next para. Learned AGA is directed to ensure that the original records from the office of the Special Deputy Commissioner, Inam's abolition, Hassan district of the relevant year, that is 1979, shall be made available to this court on the next date of hearing. So, release this matter on 22nd of February. Yes, online application. Yes, yes.
Over certain properties, instead of and they have taken certain properties. The original court system, there was a bill made only in favor of the car. The original court upheld the suit value and dismissed the suit in favor of the other sons. Then the sons came on the second. In the second appeal, the son of the court protest. After the release deeds of the sons in favor of legal, properties become the self-acquired property of legal. Therefore, the wife of Meet and Daya did not have any right to make a bill of it. Bill was made by the wife. Not. So the wife of Meet and Daya did not have any right. I gave a preliminary degree for 1/6 share in respect of all properties, given to the predeceased son's widow. And in the meantime, what happened? The son's, the daughter, Nirmala, my God, who was very recent into the will. So before she had sold 2 acres of property, this went and said in favor of the respondent purchase. Not 4 acres. 2 acres was sold after 4 acres. Now not like that. The purchaser suddenly emerged in 2000, somewhere in 2020. And he got a mutation payments. Expected to purchase. Though there was a agreement bidding, and there was a preliminary degree for purchase. Immediately we filed appeal for AC. AC rightly said, since there is a preliminary, three shares common. And also that if equities are to be worked out, the joint names are to be made. In the articles. With the direction. It can go the AC day by the appeal, but the DC is not unfortunate. He went on a tangential point, saying that, this, until the appeal is decided, cannot be brought in the time. And second point is, he said that this was a 4 year. So the way proceeding, therefore you go for area, cannot come for AC. The AC has clearly given a finding. These buildings are buildings for change of use. All that we request that in terms of the update, let that be in directives. So that it can continue with directives till the matter is decided.
ಬರೋದಿಲ್ಲ ತಪ್ಪಾಗುತ್ತೆ. See, ಇರ್ಬೋದು.
Yes.
But the revenue authorities cannot take such a decision. That during pendency of the suit it was sold and therefore we cannot recognize the sale deed. ಅದನ್ನ ಹೇಳಕ್ ಬರೋದಿಲ್ಲ ಅವ್ರು. ಹಾ.
That is what the AC has. But the AC has not said that their name should be removed. It is rightly so, because purchaser may in equity get some portion. Because he has one share.
Yes. Yes.
But the remaining share, the purchaser cannot take the. What he has done, purchaser unfortunately.
Where is the RTC?
RTC.
ಇವಾಗ ಯಾವ ತರ ಇದೆ ಅದು?
Individual name.
Where is the RTC? Annexure G 227. Sumer Chand 2 acres. Ladu Ram ಅದ್ಯಾರದು? ಅಲ್ಲ, ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್ ಈ ಹೆಸರುಗಳು. ಸುಮೇರ್ ಚಂದ್ ಇಸ್ ದಿ ಪರ್ಚೇಸರಾ? ಸುಮೇರ್ ಅಲ್ಲ, ಸುಮೇರ್ ಚಂದ್ ಇದೆಯಲ್ಲ 2 acres. Is the purchaser? Is this respondent? And who is this Ladu Ram? ಮತ್ತೆ ಇಲ್ಲಿ in the RTC ಈ ಸುಮೇರ್ ಚಂದ್ ಯಾರು? ಅದೇ sir, there are two names. There are two names. Ray, I am asking you. Sumer Chanda, he has gifted it to Sumer Chand.
But Sumer Chand is a party to be. Sumer Chand is a party to be AC%.
ರೀ ಲಾದುರಾಮ್ ಪರ್ಚೇಸರ್ ಅಂತ ಹೇಳ್ತಿದಾರ ಅವರು. 2 ಸೇಲ್ ಡೀಡ್ ಆಗಿದೆಯಾ? ಎರಡು ಒಂದೊಂದು ಎಕರೆನಾ ಅಥವಾ ಇಬ್ರಿಗೂ 2 ಎಕರೆ? ಅವ್ರು 4 acres ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ. 2 acres in 2 separate sale deeds.
Not 9 on one side. One side is not 9 on another side. 2 acres. This comes that was 2 acres. Ladura and Dika.
ಅದು ಒಂದು ಸೇಲ್ ಡೀಡ್ 2 acres. ಇನ್ನೊಂದು ಸೇಲ್ ಡೀಡ್ ಸೇಮ್ ನೇಮ್ ಸೇಮ್ ಪರ್ಸನ್
ನಿರ್ಮಲ ವತ್ಸಲ ಒಂದು ವತ್ಸಲ ನಿರ್ಮಲ ಒಂದು ಡಾಟರ್ ಒಂದು ಪ್ಲೇಸ್
ಬಟ್ ಹೂ ಇಸ್ ದಿಸ್ ಸುಮೇರ್ ಚಂದ್? ಅದ ಹೆಂಗ್ ಬರುತ್ತೆ? ಅವ್ರ ಹೆಸರು ಹೆಂಗ್ ಬರುತ್ತೆ?
ಪರ್ಚೇಸ್
ರೀ ಲಾದೂರಾಮೆ ಪರ್ಚೇಸ್ ಮಾಡಿರೋದು 2 ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೂ.
and Sumer Chand one side.
ಹಾ
Karnataka and his wife.
ಅದು ಆರ್ಟಿಸ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಹಂಗಾದ್ರೆ. ದಟ್ ಆರ್ಟಿಸ್ಟ್ ಹ್ಯಾಸ್ ನಾಟ್ ಬೀನ್ ಪ್ರೊಡ್ಯೂಸ್.
Document number 1312
ಇದೆಯಾ? ಎಲ್ಲಿದೆ? ಬೇರೆ ಇದೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಇಲ್ಲಿ. ಯು ನಾಟ್ ಪ್ರೊಡ್ಯೂಸ್ಡ್ ಇಟ್.
But EC's order says exclusive in the name of purchase. But AC order says jointly in the name of purchasers until equities are.
We will do one thing. We will direct. ಬಂದಿದೆಯಲ್ಲ ಆಗ್ಲೇ ಕೋರ್ಟ್ ಸ್ಟೇ, ಅದು ಹಳೇದದು. We will direct the entry of the decree passed in OS number so and so in column number 12 and await the outcome of the FDP proceedings.
Still
They cannot, because that is why I am saying we will direct entry of the pendency of the FDP proceedings in terms of the preliminary decree passed in OS number so and so. Once it comes there, it means no one will be able to purchase it, because there is already entry. Encumbrance. It is nothing but encumbrance. Allah, see, the revenue authorities should not be permitted to go into all these questions. It is for you to work out the remedy before the final decree proceedings. ಏನು ತೀರ್ಮಾನ ಆಗುತ್ತೋ ಅದರ ಪ್ರಕಾರ the entry will come. But in the meanwhile, to protect the interest of the persons, since there is already a preliminary decree, we will direct the entry of that in the column number 12, so that they will not be able to deal with the property anymore.
DC order has to be stayed. Because DC order says exclusive on name.
All right.
This is the.
ಆಯ್ತು. We will direct the entry of that preliminary decree and pendency of the FDP proceedings, and whatever decision falls out of the FDP, accordingly the names will be entered. Yes. Barkal. Brother. All right. But you before the assistant commissioner and deputy commissioner, it is in respect of only one survey number or ಎರಡು ನದಿ. Where is the order of the Tahsildar?
Challenging the limitation increase in the mark 26/3/21 should be R1 in terms of R22/24. Respect of land value, old survey number 21, let's say, and new number 32 and old survey number 21, new survey number 32.
ಅದು ಒಂದೇ ಒಂದು ಮ್ಯೂಟೇಶನ್ ನಂಬರ್ ಬರೋದಿಲ್ಲ, ಎರಡು ಬರಬೇಕಾಗಿತ್ತು. ಇದೆ 2 separate properties, 2 separate mutation orders should have been there. ಇಲ್ಲ ಸೇಲ್ ಡೀಡ್ ಅಲ್ಲೇನೆ ಸೆಪರೇಟ್ ಆಗಿದೆಯಲ್ಲ. ಎನಿವೆ learned AGA takes notice for response number 1 to 4. Learned counsel. N. Shivkumar has entered appearance. Correspondence number 5. By filing a caveat petition. Stop. Response number 6 to 29. Are the family members of the petitioner's family. Members of the petitioner's family. Family members, members of the petitioner's family. Huh? Avaro? Except except response number 5, 6 and 7. ಹಂಗಾದ್ರೆ response number 8 to ಅಂತ ಹಾಕೊಳ್ಳಿ. Response number 8 to 24 29 are members of the family of the petitioners. While response number 5 to 7 are the subsequent purchasers who are represented by learned counsel Sri N. Shivkumar. Stop. Next para. Learned senior counsel Sri Vivek Subbareddy, appearing on behalf of the petitioners, submits that two members of the family had filed a suit in OS number 202 of 2007, seeking partition and separate possession of the suit schedule properties, which include survey number 32/4 and 32/5 of Dargapura village, Kasba Hubli, Dodbalapur Taluk. During the pendency of the suit, respondents number 5 to 7. Respondent number 5 5 to 7 purchased 2 acres each in survey number 32/4 and 32/5 under registered sale deeds. 2 acres each in survey number so and so, survey number so and so. 3/7/2004. 2004. So, the trial court passed a preliminary decree. The trial court dismissed the suit by a judgment dated 17th of April 2007. So, however, in the regular first appeal, in RFA 1677 of 2007, a division bench of this court, by a judgment dated 11/3/2014, set aside the judgment passed by the trial court and declared that defendants number 3, 3A, B and C all put together are entitled to 1/6 share in the suit schedule properties. So, Similarly, other remaining surviving sons and daughters who are legal heirs of late Sri A. Nilakantaya would be entitled to 1/6 share. So, it was also directed that the alienees are entitled to work out their remedies in the final decree proceedings. So, in the meanwhile, subsequently, the petitioners herein approached the Assistant Commissioner, Doddaballapura subdivision, invoking the appellate jurisdiction under section 136(2) of the Karnataka Land Revenue Act, 1964, challenging the mutation entries made in MR number T6/2020-21, which was passed on the strength of the 2 registered sale deeds. Full stop. The Assistant Commissioner by order dated 26/9/2022 allowed the appeal, set aside the mutation entry in MR number so and so, and directed the Tahsildar to mutate or effect the kata and to enter the names of the appellants therein, along with respondents number 2 to 24 jointly. Aggrieved. Respondents number 5 to 7 approached the Deputy Commissioner, invoking the revisional jurisdiction under section 136(3) of the Act. The Deputy Commissioner passed the impugned order dated 25/1/2024, setting aside the orders passed by the Assistant Commissioner. Learned Senior Counsel submits that as a consequence of the orders passed by the Deputy Commissioner, the names of response number 5 to 7 alone will remain in the RTC, when admittedly they purchased the properties during the pendency of the suit, and there being a direction at the hands of this court in RFA number so and so that the alienees shall have to work out their remedies in the final decree proceedings. Full stop. Learned Senior Counsel would therefore submit that the Assistant Commissioner was right in his decision to enter the name of all the persons jointly, along with response number 5 to 7. Stop. Next para. For contra, Learned Counsel for response number 5 to 7 would submit that even in terms of the judgment and decree passed by this court in RFA number so and so, the alienees will have to work out their remedy before the final decree proceedings, and before the final decree proceeding is passed, the petitioners herein should not have approached the Assistant Commissioner seeking for entry of their names. Full stop. Next para. There is substance in the argument on both the sides. Stop. During the pendency of the RFA or even after the judgment and decree was passed by this court in RFA number so and so, the petitioners could not have filed an appeal before the assistant commissioner invoking the appellate jurisdiction under section 136 bracket 2, comma, without the final decree proceedings being drawn. Full stop. However, comma, it is also important that the interests of all the parties are protected till the final decree is drawn up. Full stop. This has become obvious, comma, since admittedly respondent number 5 has executed a gift deed in favor of his daughters, even subsequent to the orders passed by this court, and therefore there is all possibility of the of response number 5 to 7 alienating the property during the pendency of the final decree proceedings. Full stop. In that view of the matter, this court proceeds to pass the following order. 1. The writ petition is allowed in part. Full stop. The impugned orders passed by the assistant commissioner as well as the deputy commissioner are set aside. Full stop. Next. The Tahsildar Doddaballapura Taluk and the Deputy Commissioner, Bangalore Rural District, are hereby directed to enter in column number 12 of the RTC the judgment and decree passed in RFA number so and so, and the pendency of the FDP final decree proceedings in FDP number 10 of 2014. Stop. The such entry shall continue till the final decree is drawn up. Full stop. Thereafter, comma, in terms of the final decree, the persons who acquire rights over the land in question shall be entitled to have their names entered in the land records. Full stop. Next para. Till such time, response number 5 to 7 are hereby directed not to create any third party interest during the pendency of the final decree proceedings. Huh?
Permit me to file objection. Yeah. November 12th, anytime I will permit to file objection.
ಯಾವ್ದಕ್ಕೆ ಯಾವ petition ಗೆ ಯಾವ್ದು no you can make a application there of if all of you want a direction to be given by this court, we will give a direction. What is that? Huh? Berkeley. At the request of the learned counsel for response number 5 to 7 and the learned senior counsel for the petitioners, comma, the trial court is directed to conclude the final decree proceedings as expeditiously as possible and at any rate within a period of 6 months from the date of receipt of a copy of this order. Full stop.
Is waiting the father. Then there will not be alienation at the hands of the father, the representative of the mother.
Our party ilva illi? Huh?
Party. DC.
ಅಲ್ಲಿ not to create any third party interest ಅಂತ ಬದಲ response number 5 to 7 and the two daughters in whose favor respondent number 5 has executed gift deeds.
The case.
Thirty. 5 copies at page number 35. You are only concerned with survey number 49.
Second, our main point is in the separate material. Issue form number 10. Tahsildar issued a form number 10 in favor of the petitioner. Extent of petition number 1 to an extent of 24 months. To an extent of 32 months in favor of the petition number 2. Issue form number 10.
Really there? You have not produced it here? ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ?
Petition number 1 here 34 guntas.
34 guntas.
Pura naikni 32 gunte ಮಾಡಿ 38 gunte
34 guntas. 6 plus 6 12 ಆಗುತ್ತೆ. 1 acre 6 guntas.
34 guntas ಮಾಡಿ.
Petitioner number 1 ಅಂದ್ರೆ instead of 1 acre 6 guntas. ಎರಡನ್ನು ಕಡಿಮೆ ಆಯ್ತು.
7 and 8 and 75 based on the environment. Based on farm number 10. I approach the intent commission because for rectification of farm number 10 happens directly to the particular. The attached limitation matrix and issue for the farm. Commission will discuss the only that it is in the art of the matter is different. Farm number 10 what's good, which will not entertain the appeal. I put an appeal before.
Form number 10 is issued in terms of provision. Which is the provision? Section 55. So you have to file an application under the provisions of the Karnataka Land Reforms Act for rectification.
Instead of doing that. State commissioner is in charge of as a secretary to the land tribunal. He is under the wrong motion to challenge the mutation entry 7 and 8 and also direction to the state commission, issue direction to rectify form number 10.
Yes.
He entertained the appeal. The state commissioner dismissed the appeal holding that the form number 10 entries were made pursuant to form number 10 before the order of land tribunal. We went to the deputy commissioner. Deputy commissioner allowed by revision. Certifying the entry in the name of petitioner to extent of 1 acre 6 guntas each as per the order copy and that is concerned. Petition number 2 or 1819 has been certified pursuant to the order of the deputy commissioner. Deputy commissioner order, but they do not work. 800. Committee closed. ಪರೀಕ್ಷಾ ಮೇಲ್ಮನವಿ ಅಂಗೀಕರಿಸಿದೆ. ಪೂರ್ವ ವಿವಾದಿತರೆಲ್ಲ ಪ್ರತ್ಯೇಕ ಆದೇಶವನ್ನು ರದ್ದುಗೊಳಿಸಿದೆ.
ಯಾವುದು?
that we try to target the objects. Which is 7. ಮೇಲ್ಮನವಿ ತಿರಸ್ಕರಿಸಿದೆ ನಮ್ಮ ಅಪೀಲ್ ತಿರಸ್ಕರಿಸಿದೆ ಹಾಗೂ ರಾಜ್ಯ ಸೋದರಿ ಕ್ಷೇತ್ರ ಮಾಡಿಸುವ ಆದೇಶ FR 7/1823 FR number 8 of 2023 ದಿನಾಂಕ 28/11/82 ಮತ್ತು FR 47/19
Yes.
And I went to the deputy commissioner.
Yes.
Deputy commissioner reports that we have been granted occupancy. Our number 10 issued to a lesser extent. And the direction was issued. We actually got to rectify the entries in the revenue accounts. The operating report hundreds. That the revision petition has been allowed.
ಆಯ್ತು.
Then pursuant to that, the FR number 2/19/20 has been certified. Deputy commissioner. Page 101. Page 102 annexure J came to issue, rectifying the entries in the revenue records. Instead of questioning the order of the deputy commissioner, the respondent number 3 went ahead and appealed before the assistant commissioner again.
Who is respondent number 3?
Respondent claimed to be one of the areas of the original land, original land law.
Respondent number 5. TT Chandrasekhara.
He have challenged the order of the deputy commissioner before this court. Challenge the entry of the deputy commissioner is concerned. This order of the deputy commissioner has been implemented. MR 2 of 1819 has been certified. Correct entry to an extent of 1/6. This MR has been questioned once again before the assistant commissioner. Previously annexure J page 130. So ಆದೇಶ 17/9 MR number 2/1920. 17/9/2009. Ratings in the operating force page 117. ಅದರ ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ? 17.
ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿ
ತಿರಸ್ಕರಿಸಿದ್ದಾರೆ. That appeal has been
ಈಗ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ You can understand if the deputy commissioner
ತಿರಸ್ಕರಿಸಿದೆ ಅಂತಿದೆ. ಅಪೀಲ್ ತಿರಸ್ಕರಿಸಿದೆ ಅಂದ್ರೆ
ನನ್ನ ಅಪೀಲ್ ತಿರಸ್ಕರಿಸಿದೆ.
ಯಾವುದು?
First one. First appeal.
Annexure K.
Annexure G page 58 has been dismissed.
ಅಲ್ಲಲ್ಲ annexure K.
Annexure K has been allowed. Annexure K allowed. Annexure K has been allowed. Directing the respondent number 5 to approach this report. Where is the operating force? ಪ್ರಕರಣದಲ್ಲಿ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳ ಆದೇಶದ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ ಆದೇಶ ರೀತಿಯ ಶೇಷಮ್ಮ ಚಂದ್ರನಾಯಕ ಅವರಿಗೆ 89/2ರಲ್ಲಿ 1 ಎಕರೆ 1.60 1.06 ಎಕರೆ ಹಾಗೂ ರುದ್ರನಾಯಕ ಮಂಜನಾಯಕ ಅವರಿಗೆ 1.06 ಎಕರೆ ಮತ್ತು ವೀರಭದ್ರಪ್ಪ ಅವರ ವಾರಸುದಾರರಿಗೆ ಉಳಿದ ಜಮೀನನ್ನು MR number 2/1920 17/9 ನಂತರ ಖಾತೆ ಬದಲಾವಣೆ ಮಾಡಲು ಕ್ರಮಬದ್ಧವಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಮೇಲ್ಮನವಿದಾರರು ತಮ್ಮ ಕೋರಿಕೆ ಕುರಿತು ಸಿವಿಲ್ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಮೇಲ್ಮನವಿ ಸಲ್ಲಿಸಿ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳುವಂತೆ ಆದೇಶಿಸಿದರು. ಮೇಲ್ಮನವಿಯನ್ನು ತಿರಸ್ಕರಿಸಿದೆ. ರಾಜ್ಯಸಭೆಯಲ್ಲಿ ವಿಚಾರವಾಗಿ MR number 2 ಆದೇಶವನ್ನು ತಿರಸ್ಕರಿಸಿ ಆದೇಶಿಸಿದೆ. This was questioned by an appeal before the deputy commissioner against by the respondent number 5. Annexure 8 the order. Respondent number 5. The deputy commissioner allowed.
ಭೂ ಸುಧಾರಣಾ ಕಾಯ್ದೆ ಅಡಿ ಫಾರ್ಮ್ 10 ನೀಡಿರುವಂತೆ ಖಾತೆ ಎಂಡೀಕರಿಸಲು ತಹಸೀಲ್ದಾರ್
Was already implemented by virtue of the order of the deputy commissioner. But should have been questioned by the deputy respondent number 5 before this court. Instead of doing that, he went around once again, second round of litigation for the very same reason. It's again final. To 18 is the order passed by the deputy.
technically these orders were passed at your instance. under section 136. They have all the right to go before the assistant commissioner and deputy commissioner, because you should have gone before the special deputy commissioner seeking correction of form number 10.
ಅದಕ್ಕೆ ನಾನು ಅಷ್ಟೇ
That is under the provisions of the Land Reforms Act.
ಅದೇ ನಾನು ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದು. ನನ್ನ appeal ಅಲ್ಲಿ my request before the state commission is page 59 ಅಲ್ಲಿ ಕೋಡೂರು ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 49.
Anyway, this they have to come. We'll have to issue notice. ನೀವು ಫಾರ್ಮ್ ನಂಬರ್ 10 ಕರೆಕ್ಷನ್ ಮಾಡಿಸ್ಕೊಳ್ದೇನೆ
ನಾನು ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನ್ ಮುಂದೆ ಹೋಗಿದ್ದೆ.
ಬಟ್
ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರು.
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ಹೆಂಗ್ ಬರುತ್ತೆ ಫಾರ್ಮ್ ನಂಬರ್ 10 ಕರೆಕ್ಷನ್ ಮಾಡೋದು?
ಡೈರೆಕ್ಷನ್ ಕೊಡಿಸ್ತೆ ಕೇಳ್ದೆ ನಾನು.
ಹಾ,
ಅದು ಆರ್ಡರ್ ಮೇಲೆ ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ ತಹಶೀಲ್ದಾರ್ ಇಶ್ಯೂ ಫಾರ್ಮ್ ನಂಬರ್ 10 and section 55. He should be performing order of the land tribunal. He should have doing that to the lesser extent. He went to the assistant commissioner saying that the issue of form number 10 is not correct. Consequently, mutation has been done. This is contrary to the order of the land tribunal. Kindly issue direction to the tahsildar to rectify the entries and to issue
rectify
the mutation entry 7 and 8.
first to rectify the form number 10, then automatically it would follow in the revenue records. ಇದು ಉಲ್ಟಾ ಆಗೋಯ್ತು ಇದು.
But it was rejected.
So therefore you now cannot question. They could not have gone before the assistant commissioner or the deputy commissioner anta you cannot contend.
I went to the assistant commissioner. I suffered an order. There is no dispute about it.
The order passed by the deputy commissioner under 136 is not correct. So therefore they are again questioning it.
My submission is
ಏನ್ ಮಾಡೋದು? No,
not correct.
you will have to get the form number 10 corrected. Marty.
Since I get an order from the deputy commissioner, I kept quiet.
Yes. Learned AGA takes notice for response number 1 to 4. Issue notice to respond number 5. Learned counsel for petitioner is direct to serve a copy of the petition along with annexures from the learned AGA. Let them come, we'll see. ತಪ್ಪಾಗುತ್ತೆ. Without form number 10 being corrected, they could not correct only the revenue entries. ಯಾವುದು ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅದು. Till date form number 10 has not been corrected. So we will see that your grievance is considered and let them file their objections if they want to for your claim for correction of yes.
From 1973-74, an extent of 1 acre 6 quintals has been shown in the records of there is no dispute about it. 1 acre 6 quintals had entered into our name. So that date is a records of it. 1 acre 6 quintals entries is there.
Then why did you go before the revenue authorities then?
Stop. Form number 10 in the year 1989. It was reduced.
ಅದೇನೆ
ಅವಾಗ ನನಗೆ ಗೊತ್ತಾಗಿದೆ. ಅವಾಗ even today, even to this day.
89 ಇಂದ ಹಂಗೆ ಬಂದಿದೆ.
ಇವತ್ತು ನನ್ನ ಹತ್ರ 1 acre 6 quintals ಇದೆ. 23 entries, page 57. Even as on today, 83-84, 1 acre 6 quintals.
No, that is consequent to the impugned orders passed by the deputy commissioner, not impugned orders, the previous orders.
Even before passing of the.
ಅಲ್ಲ ಹಂಗಿದ್ದಿದ್ರೆ where was the need for you to go before the revenue authorities?
ಮುಂಚೆ 1 acre 6 quintals
ಇತ್ತು, ಆಯ್ತು, ಕರೆಕ್ಟ್.
So form number 10.
ಆದ್ಮೇಲೆ ಚೇಂಜ್ ಆಯ್ತು.
ಈಗ change ಅದು
ಈಗ ಅಲ್ಲ 86
84 ವರೆಗೆ ನನ್ನ ಹೆಸರು ಇದೆ.
ಕರೆಕ್ಟ್.
ಇದು 86 ಆದ್ಮೇಲೆ ಮತ್ತೆ ನನ್ನ ಹೆಸರೇ ರೆಸ್ಟೋರ್ ಆಯ್ತು. 86 ಮಾರ್ಚ್ ಸರ್ಟಿಫೈಡ್ ಪರ್ಸನ್ ಟು ದಿ ಆರ್ಡರ್ ಆಫ್ ದಿ ಡೆಪ್ಯೂಟಿ ಕಮಿಷನರ್.
ಅದೇ ಸರ್ ತಪ್ಪಾಗತ್ತದು. Without getting form number 10 corrected, there cannot be a revenue entry contrary to the form number 10. Though you may have asked for correction in form number 10, the orders were passed under 136, only correcting the revenue entries. ತಪ್ಪು. ಸರಿ ಆಯ್ತು. You have to give opportunity to them also.
Status for respect of the entries under police are very important.
No sir.
For even entries.
No.
Respect of the disputed property.
No. Yes.
Give it up. Orders.
Huh?
9.1 correct ಆಗಿದೆ.
Dealing ta.
What happened? Main serial number 9 and 12479. For the other way. What is Pleading application. Pleading application made a submission for their bench. Saying that they are independently challenged the order of the deputy commissioner. Therefore, tag along with this request. He request is correct. That is wrong.
What are the GM?
So, actually, my idea is the 2nd of February order.
Tag this petition along with WP number 3405 of 2024. ಆಮೇಲೆ ರಿಪಿಟೇಷನ್ ನಂಬರ್ ಚೇಂಜ್ ಆಯ್ತಾ? What is the number? 4351 of 2024. This is 4351 is a KLR matter. Right. Berkeley. Learned councils jointly submit that while daily orders were passed on 2/2/2024 in WP number 12479 of 2020, a direction was issued to tag writ petition number 3405 of 2024 and list both the matters on 13/2/2024. Stop. However, the writ petition number is 4351 of 2024 and the other number was only an FR number.
That means FR number 3516. Both the matter has to be connected. One repetition number and another is in FR number.
Madam, this order, based on this order, the writ petition has been placed before this court. The learned counsel has pointed out writ petition number 3405 is not the correct number. It was only the FR number.
What is repetition by the association?
That writ petition is 4351 of 2024. So along with that writ petition, it will be placed before the. So office is therefore directed to list WP number 12479 of 2020 along with WP number 4351 of 2024 before the bench which directed listing of the matters in terms of order dated 2/2/2020. It will go there, madam. We have got nothing. All right. It will come up some other time. It will come. No, I can't give date. I can't.
Consultations complaint and first time only. It had been wrong in that matter. If I number had
Sorry, I put it. Yes. This has got nothing to do with. You can proceed. Yes. ಹೇಳಿ ಫೈಲ್ ಕೊಡ್ರಿ ರೀ 3405 ಕೊಡ್ರಿ 3405 of 2024 ಕೊಡ್ರಿ yes
if first state with the communication by the respondent number in favor of respondent number.
ಮಾಹಿತಿ ಹಕ್ಕು ನಿಯಮದಡಿ ಮಾಹಿತಿ
ಅಲ್ಲ ಅದು ನಾನು on the right to information act la government order ತಗೊಂಡಿದೆ.
ಏನು?
And the order by virtue of which the land in 730 of Irvaki village, Sadra Talu, is granted in favor of respondent number 4. The RTC.
Rishi Vishwavidyalaya.
ಎಲ್ಲ revenue even 2024 or 2 petition and settled late, without even causing a notice to me, including my land, it has been granted. None previous original grantee and grant ಆಗಿ way back to year 1951 ಅವರಿಂದ ನಾನು purchase ಮಾಡಿ subsequent to the death of the purchaser these children they came on the card and their names are already entered.
What is the annexurial?
Annexurial is the grant in favor of R4. Are 850 village into 80 acres total land and completed only grant. Survey number 30. In the very same survey number 30, 4 acres land original grantee in the father purchase money, our invitation.
2015.
Please.
Annex-
Notice illa, survey madilla, entered illa, straight away. In December 2023, on 18th, when the respondent to the court came along with police and we came to know that it has already been granted in their favor. On notice seta illa, why should grant cancel madilla? Now, even 2024 under petitioner's name appear in the RTC, along with crop information. I have developed the land.
Shivlingaya.
Shivlingaya and Nagarajaya, Makru, presently joined. Subsequent to the death of their father, Chandra. KPDCL in the letter ಬರುತ್ತೆ ಬೋರ್ವೆಲ್ ಹಾಕ್ಸಿದ್ವಿ ಅದರದ್ದು ಎಲೆಕ್ಟ್ರಿಸಿಟಿ ಕನ್ಸಂಪ್ಷನ್ ಚಾರ್ಜಸ್ ಫಿಕ್ಸ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಇಷ್ಟೆಲ್ಲ ಇತ್ತು ಅದೇ ರೆವಿನ್ಯೂ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಎಲ್ಲಾ ಎಂಟ್ರೀಸ್ ಇದ್ರು totally disregarding my rights. At least one simple notice why it should not be cancelled and if you are in possession A in regards the very same revenue department are records. In spite of that, at least the principles of natural justice set up follow ಮಾಡ್ತಾರೆ. They grant it in favor of all. ಅದರ grant certificate ಅನ್ನು ಹೇಳ್ತಾರೆ.
You have to say anything? Already, there is nothing said in this order of the year 2015.
No, my lord, nothing. ಅಲ್ಲಿ ಅವರು ಯೂನಿವರ್ಸಿಟಿ ಅವರು ಬೇರೆ ಯಾವ ಇಮೇಜಿಂಗ್ ಲ್ಯಾಬ್ಸ್ ಕೇಳ್ತಾರೆ. ಅಲ್ಲಿ ತುಂಬಾ ಪ್ರಾಬ್ಲಮ್ಸ್ ಇದೆ, ಕೋರ್ಟ್ ಕೇಸಸ್ ಇದೆ, ಅದಕ್ಕಾಗಿ ಇಲ್ಲಿ ಗ್ರಾಂಟ್ ಮಾಡ್ತಾರೆ ಅಷ್ಟೇ.
There may be other extent of land. Why are you? How? See, if your name is there in the RTC, how is it possible that they simply grant it to some other person? Not that may not be correct.
ಅಲ್ಲ ಅಡಿಕ್ಷನ್ ಏನು ನೋಡ್ಬೋದು.
ಇವಾಗ ಏನಾಗಿದೆ? What is the problem?
Totally 30 survey number 30, survey number 65 and 66 ಮಾಡಿದ್ರು. ಅದರಲ್ಲಿ 80 acres.
Because there is nothing found in respect of you or your entry in the land records in the impugned order. It can be presumed that they intended to do nothing in respect of your property.
No, my lord, not at all. None comprehension is to total 80 acres measurement. Survey number 38. Total 80 acres, it has been granted in favor of all. The grant certificate financial year may kindly peruse. Page 187, 50. Of the petition. Last column narrative ಹಾಕಿದ್ದಾರೆ. Measures totally 80 acres in the bottom and ಹೇಳ್ತಾರೆ first. ಆ entire 80 acres they have granted to ನಂದು ಒಂದೇ ಅಲ್ಲ ಇವನ adjacent plants ಇದೆ ಎಲ್ಲರೂ
ಸರ್ವೆ ನಂಬರ್ 30ರಲ್ಲಿ 80 ಎಕರೆ.
Totally it measures 80 acres, entire 80 acres are in that.
Yes.
Before that, I would like to make.
Learned AGA takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioners is directed to serve a copy of the petition along with annexures on the learned AGA.
The interim prayer is not uncovered with you to direct them to dispossess ಅಂತ ಆಗ್ತಿದೆ. ಅದಕ್ಕೆ ಅದನ್ನ fairly I have brought it to the notice of the court. Not to dispossess them.
Next para. Learned counsel for the petitioners submits that it is not disputed at the hands of the respondent revenue authorities that in terms of the grant made in the year 1957 in favor of Sri Dharma Shetty. His name was entered in the land records in respect of 4 acres in survey number 30 of Iruvakki village, Sagara Taluk, Shumaga district. Stop. The petitioner's father, Sri Channabasvaya, purchased the said lands from Parma Shetty under registered sale deed dated 22/9/1971. Stop. The names of Sri Channabasvaya were also entered in the land records. Stop. After the death of Sri Channabasvaya, the names of the petitioners have also been entered in the RTC in terms of MR number, in terms of MR, stop, H1 for 2018-19, dated 11/9/2018. Stop. However, without the knowledge of the petitioners, the impugned government order dated 31/1/2015 has been issued by the state government, revenue department, reserving (130 acres and 22 guntas in various survey numbers, including 80 acres of land in survey number 30 of Iruvakki village, and another extent of 777 acres, 7 guntas of land in favor of the fourth respondent, Agricultural and Horticultural University. Stop. Learned Council submits that consequent to the impugned orders, a grant certificate has also been issued at Annexure L in favor of the fourth respondent. Stop. Learned Council submits that the impugned government order does not mention anything about the rights of the petitioner or their names being found in the revenue records. Full stop. Correct. Consequently, there shall be an ad interim order of stay of the impugned government order at annexure K. Insofar as 4 acres of land in survey number 30 of Iruvakki village is concerned, in terms of the entries found in the RTC. At annexure G, comma, till the next date of hearing. ನಂಬರ್ ತಪ್ಪಾಗಿ ಬಂದಿದೆ, ಡಿಲಿಂಕ್ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಅದು GM ಮ್ಯಾಟರ್, ಅದು FR ನಂಬರ್, ಇದು ಆಕ್ಚುಲಿ ರಿಪಿಟೇಷನ್ ನಂಬರ್. ಅವ್ರು ಹೇಳಿದ್ದೆ FR ನಂಬರ್, ಅದನ್ನೇ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದೀನಿ.
Survey number 65 and 66. It is survey number 900. Survey number 30.
No, no.
Survey number 65.
No. In that order, only survey number 30 is found. Yes. We'll see.
Correction on the to now to direct disposal ಅಂತ ಆಗ್ತಿದೆ ಆಮೇಲೆ ನಾಳೆ ಆಧಾರ್ ವೀಕ್.
ಯಾರಮ್ಮ ಹಂಗ್ ಹೇಳ್ತಾರೆ? Who is going to make such a submission? We'll see. Yes. All right. ಆಯ್ತು, ಬರ್ಕೊಳ್ಳಿ. The learned counsel for petitioner has fairly submitted that a typographical error has occurred in the interim prayer by the word no, not commercially, is missing. Not is missing, and it would be construed as if the petitioner is seeking directions to dispossess themselves from the land in question. Full stop. The submission is taken note of. Yes.
Party in the individual. I have made my window also as a party. So I have put a note on. What is the mentioned date? In that my lord, my vendor is a party. I have made him also as a party. Party my party.
ಏನ್ proceedings ಇದು?
We got 136 proceedings.
Huh?
136.
Deputy Commissioner. ಹಾ.
2006 ಅಲ್ಲಿ ಒಂದು ಸರಿಯಾದ ಪುಸ್ತಕ, that is petition number 2 had purchased the property. ಅದೇ ಖಾತಕ್ಕೆ ಕೊಟ್ಟಾಗ the name of the vendors, ಅವರು ತಿಮ್ಮಪ್ಪ ಕೂರ್ಮಾನ್ ಅನ್ನೋರಿಗೆ ಒರಿಜಿನಲ್ ಅವ್ರ ಹೆಸರಿತ್ತು, ಅವ್ರು ತೀರಿ ಹೋದ್ಮೇಲೆ ಅವರ ಲೀಗಲ್ ಹೇಡ್ಸ್ ಎಲ್ಲರೂ ಕೂಡ they sold the property to the petition number 2. Since their name was not found in the record of rights, the mutation was rejected. Subsequently, their name was entered, the names of all the legal heirs were entered in the record of right. And without disclosing the same to us, they sold this property to the respondent number 4.
This petitioner number 2 did not contest the matter.
He only filed the appeal before the assistant commissioner.
Huh?
He only filed the appeal before the assistant commissioner challenging the mutation.
Thereafter, Yavaga, when did he file it?
It is in the year 2021.
2021. And when did you purchase the property?
After the order passed in the year, after the order passed in the AC, that is dated 25/9/2023.
Where is the order of the assistant commissioner?
Assistant commissioner order at page number 36, annexure. But as on the date of passing the order by the deputy commissioner, the property was converted from agricultural to industrial purpose.
Please read this in page number 59, the last paragraph.
In page 3.
Internal page number 2 of the order of the Assistant Commissioner.
Yes. Appeal ದಾಖಲೆಗಳಿಗೆ.
ಕೆಳಗಡೆ second one.
ಅಪೀಲುದಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಖುದ್ದು ಹಾಜರಾಗಿ ನೋಟರಿ ದೊರಕಿದ ಪ್ರಮಾಣ ಸಲ್ಲಿಸಿ ಅವು ಚಿತ್ರದುರ್ಗ ಜಿಲ್ಲೆ ಚಿತ್ರದುರ್ಗ ತಾಲೂಕು ಹಿರೇಘಟ್ಟನೂರು ಹೋಬಳಿ ಲಿಂಗನಹಳ್ಳಿ ಗ್ರಾಮದ ಈ ಸಭೆ ನಂಬರ್ 20/1 ರಲ್ಲಿ 3 ಎಕರೆ 20 ಗಂಟೆ ಜಮೀನನ್ನು ಇನ್ಸಾರ್ ನಂಬರ್ ವಹಿಸೋ ಅದನ್ನು ತಿಮ್ಮಪ್ಪ ಗುರುಮನ್ ಹಾಗೂ ಅವರ ಕುಟುಂಬಸ್ಥರಿಗೆ ಶುದ್ಧಕ್ರಯ ಮಾಡಿಕೊಂಡಿದ್ದು ನಂತರ ಎಂಆರ್ ನಂಬರ್ ವಹಿಸೋ ಗಂಟೆ ದೇವಾಣ ನಂಬರ್ ಸದರಿ ಎಂಆರ್ ತಿರಸ್ಕೃತವಾಗಿರುತ್ತದೆ. ನಂತರ ಅಪೀಲುದಾರರು ಹಾಗೂ ಅವರ ಮೊದಲಿಗೆ ಪ್ರಯುಕ್ತ
MR ನಂಬರ್ ತಿರಸ್ಕೃತವಾಗಿರುತ್ತದೆ. ಹಾ
Petition was rejected on the
ಆಯ್ತು, ಓದಿ ನೆಕ್ಸ್ಟ್ ವರ್ಸ್.
end of name was not.
ನೆಕ್ಸ್ಟ್ ಓದಿ.
ಈ ಮಧ್ಯೆ ಜಮೀನನ್ನು ಅಪೀಲುದಾರರಿಗೆ ಮಾರಾಟ ಮಾಡಿದ್ದ ತಿಮ್ಮಪ್ಪ ಕುಟುಂಬದ ಕುಟುಂಬದವರು ಹಾಗೂ ಇತರರು ಮೋಸದಿಂದ ಸಬ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಅವರ ಕಚೇರಿಯಲ್ಲಿ ಎತ್ತರಾಗಿ ಓಂಕಾರರೆಡ್ಡಿ ಎಂಬುವರಿಗೆ ಕರೆ ಮಾಡಿ ಎಸ್ಆರ್ ನಂಬರ್ ವಹಿಸೋ ಅಂದ್ರೆ ಸದರಿ ಎತ್ತಿರಾಜು ಅವರಿಗೆ ದಾಖಲೆಯಾಗಿರುತ್ತದೆ. ಈ ಜಮೀನನ್ನು ಅಪೀಲುದಾರರು ಕ್ರಯಕ್ಕೆ ಪಡೆದುಕೊಂಡಾಗ ಈ ಸರ್ವೆ ನಂಬರ್ 20/1 ಬಿ ಒಂದರಲ್ಲಿ ವಿಸ್ತೀರ್ಣ 6 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನಿತ್ತು. ನಂತರ ಈ ಜಮೀನನ್ನು 3 ಎಕರೆ ರಾಣಾ ಪ್ರತಾಪ್ ಸಿಂಹ ಎನ್ನುವರಿಗೆ ಖಾತೆಯಾಗಿರುತ್ತದೆ. ಇನ್ನುಳಿದ 3 ಎಕರೆ 20 ಗುಂಟೆ ಜಮೀನು ಸರ್ವೆ ನಂಬರ್ 20/1 ಒಂದು ಬೋರ್ಡಾಗಿ ಕ್ರಯವಾಗಿರುತ್ತದೆ. ಅಪೀಲುದಾರರು ಇದೇ ಜಮೀನನ್ನು ಮೊದಲ ಕ್ರಯಗಾರನಾಗಿ ಹೊಂದಿರುವುದರಿಂದ ಕಾನೂನಾತ್ಮಕವಾಗಿ ನಾನೇ ನಿಜವಾದ ಮಾಲೀಕನಾಗಿದ್ದು ನನ್ನ ಕ್ರಯ ಪತ್ರದಂತೆ ಈಗಾಗಿರುವ ಎಂಆರ್ ನಂಬರ್ 2016 ಹಾಗೂ ಎಂಆರ್ 24/2017 ದಿನಾಂಕ 27/2017 ವಜಾ ಮಾಡಿ ನನ್ನ ಹೆಸರಿಗೆ ನೋಂದಣಿ ಕ್ರಯ ಪತ್ರದಂತೆ ಖಾತೆ ಮಟ್ಟದವರೆಗೂ ನಾನೇ ನಿಜವಾದ ದೈವ ಈ ಅಂಶಗಳನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ಒಟ್ಟಾರೆಯಾಗಿ ಈ ಪ್ರಕರಣವನ್ನು ಪ್ರದರ್ಶಿಸಿದಾಗ ಈ ಪ್ರಕರಣದಲ್ಲಿ ಅಪೀಲುದಾರರು ವಿವಾದಿತ ನೋಂದಾಯಿತ ದಸ್ತಾವೇಜಿನ ದಿನಾಂಕ ಖರೀದಿಸಿದ್ದು ಹಕ್ಕು ಬದಲಾವಣೆ ಮಾಡಬೇಕು. ಆದರೆ ಎರಡನೇ ತತ್ವವಾಗಿ ಕರ್ನಾಟಕ ಭೂಕಂದಾಯ ಅಧಿನಿಯಮ 1964 ವಿಧಾನಗಳನ್ನು ಪಾಲಿಸಲು ಅವಕಾಶವನ್ನು ಕೊಡಲು ನೇರವಾಗಿ ನಿಯಮ ಪಾಲಿತವಾಗಿದೆ. ಪ್ರತ್ಯೇಕ ಜಮೀನನ್ನು ಮಾರಾಟ ಮಾಡಿದ ನಂತರ ಜಮೀನು ಮಾಲೀಕರಾದ ವಾರದವರೆಗೆ ಯಾವುದೇ ಹಕ್ಕು ಬರುವುದಿಲ್ಲ. ತದನಂತರ ಖರೀದಿಸುವ ವ್ಯಕ್ತಿಯ ನೋಂದಣಿ ಕಚೇರಿಯಲ್ಲಿ ಪರಿಶೀಲಿಸಿಕೊಳ್ಳಬೇಕಾಗುತ್ತದೆ. ನಂತರ ನಡೆದ ಮಾರಾಟದ ವಹಿವಾಟದ ಎಂಆರ್ ನಂಬರ್ ವಿಧಾನದಂತೆ ಮಾಡಿರುವುದು ಕಂಡುಬಂದಿದೆ. ಆದ್ದರಿಂದ ಈ 2 ಪ್ರಸ್ತುತ ಆದೇಶಗಳು ನಿರ್ದಿಷ್ಟವಾಗುತ್ತದೆ. ಈ ಪ್ರಕರಣದಲ್ಲಿ ಪ್ರಸ್ತುತ ಜಮೀನು
So he has decided that they could not have executed another sale deed. He allowed your that person's appeal.
Yes.
Now what are the deputy commissioners holding?
Next payment. Third page of the article.
And this petitioner number 2 doesn't even bring to the notice of the deputy commissioner that he has sold the property.
Because that he hasn't done. He has filed the call through the advocate.
Yeah.
Thereafter, he sold the property and he did not participate. Other advocate.
ಅದೇ
Some reason. And but I was in the meanwhile, it was converted from agriculture to industrial purpose. I have produced the document. They were aware of the transaction that annexure J is the conversion. And after that, this order came to be passed, where my lord has been said that
all becomes disputed question of title, sir. How can the revenue authorities go into all this?
I know, but the thing is that
You have to
first
work
they
out
have to
remedy
be
even
important. First they said
ಹಂಗೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಸರ್. That application was rejected.
that rejected on the ground. That
We are not concerned of all that.
I do
Therefore,
minutes.
The deputy commissioner is right if he has held that the disputed questions have to be decided by civil court. The revenue authorities will not be permitted to go into all this matter.
The commissioner also had like that, but the thing is that the subsequent purchaser has to.
Yes.
offer the-
Then he has proceeded to say all this.
Outcome is correct, but the assistant commissioner is right to say that the subsequent purchaser has to approach the committed.
ಆಯ್ತು. Office objection is overruled. Next para. Learned HCGP takes notice for response number 1 to 3. Issue notice to respond number 4. Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on the learned HCGP. Yes. Let him come.
Otherwise, my lord, then.
Sir, ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅಂದ್ರೆ ಎಸ್ ಹಾ has been complied. The counsel for the petitioner submits that the office objections will be complied in a day or two. Full stop. If the office objections are complied, list this matter for preliminary hearing on. You want it on 15th? 15th of February. Podi and Durast. Podi, you are seeking for Podi and Durast. Online application ಹಾಕ್ಬೇಕು. ಬರೋದಿಲ್ಲ. Online application ಹಾಕಿ within 2 months it will be considered. Yes. Office objections are over. ಏನು office objection? Court fees ಏನಾರು ಇದೆಯಾ? Office objections are overruled. Yes. Disposed of. ಅದು ಕೊಡ್ತಾರೆ ನಿಮ್ಗೆ. Petition number ಕೊಡ್ತಾರೆ. Same order. Except survey number ಏನಾರು ಇದ್ರೆ ಅದನ್ನ ನೋಡಿ changes ಮಾಡ್ಕೊಡಿ ಅಷ್ಟೇ. ಮಿಕ್ಕಿದೆಲ್ಲ same order. They have filed online application. It will be considered. ಅವ್ರು ಕೊಡ್ರಿ ಅದು ಯಾವ್ದು? Yes.
Appealing for petition, your lordship. There for a week's time, your lordship. Serial number 14, your lordship.
13. We are still in here. 13. Last time office objections overruled ಮಾಡಿದ್ರಲ್ರಿ. ಅಲ್ಲ 13 ಅಲ್ಲಿ ಅದಲ್ಲಮ್ಮ ನಿಂದಲ್ಲಮ್ಮ. Office objection is overruled. Why they are listing it for office objections again? Yes.
Grant of land was 94.
Huh.
Question was really which were false for what's in consideration is the interpretation of subsection 294. I just point out why we are approaching. 94A.
You are calling in question the virus, is it?
So, but that words may really become not very necessary. Print words, notice why. The reason is the state government now issues a notification without any application of mine. This controversy is 94A provides that there shall be a committee constituted for the purposes of considering application for regularization from outside, of which members of the legislative assembly will be a member, and this will be constituted for each legislative assembly. Now, for whatever reason, the subsequent amendment to the act said that it is open for you, if you are of the opinion, that you could also constitute an additional committee. And that additional committee members can be nominated by the state. Initially, it was the assistant commissioner. The further amendment said that any person can be nominated to this additional committee.
ಏನು additional committee ಅಂದ್ರೆ?
For the same purpose. For the same purpose. The same purpose. The irony is this one. Whereas 94A1 was mandates.
ಅಲ್ಲ additional ಅಂತಂದ್ರೆ ಎರಡು ಇರುತ್ತಾ?
They have given them the discretion to constitute. In reality, what happens to us? For instance, in this case, there are totally 30,000 cases pending for that legislative assembly constituents. The member of the legislative assembly is made the chairman for the principal committee as per 94A. Within 1 month, they constitute an additional committee, and it is incidental that the member who lost the election is made the chairman, and out of 30,000 cases, about 23,000 cases are transferred to this election. Virtually making the principal committee works.
Let us see that.
Yes.
Directors first Lordships will kindly see the constitution of the committee.
Let us see the notification. Change. What changes were brought?
But I am bringing to Lordships what is that said. Kindly see first the committee, principal committee which has been constituted. At towards
Notification making that provision for additional
that is 94 94A.
amendment ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರಾ?
Oh, subsequent amendment took place. 94A. What's his name?
Huh.
94A subsection 1, subject to such rules as may be prescribed. The state government shall by notification constitute, this is necessary, shall constitute. For each constituency of the legislative assembly, a committee consisting of such number of members, not exceeding 5, of whom one shall be a member of the legislative assembly for the purposes of grant of land under subsection 4. Tahsildar and secretary. Now kindly see 2A, that is the amended provision. The state government may, if it is of the opinion, there is necessity of formation of opinion. If it is necessary, constitute one or more additional committees for the taluk for the purpose of grant of land in subsection 4, consisting of such number not exceeding 5, as may be prescribed, and state government shall nominate from among the members one of them as the chairman and another as secretary of the committee. When an additional committee is constituted, the deputy commissioner shall determine the jurisdiction of the committee and the additional committee and transfer the pending applications to the respective. Kindly see the rule also, 108. And then 8EE, additional committee. 8EE. The additional committee shall consist of the following members, namely a person nominated by the state government as chairman, 2 persons of course nominated by the state government, one of them scheduled caste, scheduled caste. Now, the original committee, principal committee, shall be constituted with number of the legislators. Additional committee, if you are of the opinion that there is a necessity for constituting an election, as to why you constitute, and then they give a carta blanco, you can nominate any person in the chair. So in this case, what happens is 4 reasons are required. First, the principal committee is constituted. What you have to see at page number 66. It is not 94A committee, first committee, subsection 1. Karnataka Bhukandaya Adhiniyama 1966. 4A ಪ್ರದತ್ತವಾದ ಅಧಿಕಾರವನ್ನು ಜಿಲ್ಲೆ ಬೆಂಗಳೂರು ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರದ ಬಗರ್ಹುಕಂ ಸಾಗುವಳಿ ಸಕ್ರಿಯೀಕರಣ ಸಮಿತಿಯನ್ನು ಈ ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಮುಂದಿನ ಆದೇಶದಲ್ಲಿ ಈ ಕೆಳಗೆ ಚೇರ್ಮನ್ is the member of the legislative assembly. This is on 2/11/2023. Now let's kindly see within 1 month at annexure A, page 29. So that what may I request Watson to kindly see annexure B, page 30. This is constitution of additional committee. Additional committee losses get annexure B, page 30. Second paragraph. See that. ಅದರಂತೆ ಉಲ್ಲೇಖಿತ ಎರಡರ ಸರ್ಕಾರದ ಆಡಳಿತದಲ್ಲಿ ಬೆಂಗಳೂರು ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ರಚಿಸಲಾಗಿರುವ ಹೆಚ್ಚುವರಿ ಸಾಗುವಳಿ ಕೃತ್ರಿಮಕರಣ ಸಮಿತಿ ಈ ಕೆಳಗೆ ಬೆಂಗಳೂರಲ್ಲಿ ಬರುವ ಗ್ರಾಮಗಳ ಅರ್ಜಿಗಳನ್ನು ಇತ್ಯರ್ಥಪಡಿಸಲು ಕ್ಷೇತ್ರ ವ್ಯಾಪ್ತಿಯಿಂದ ನಿಗದಿಪಡಿಸಿ ತಕ್ಷಣವೇ ಬಗರ್ ಸಮಿತಿ ಬಾಕಿ ಇರುವ ಅರ್ಜಿಗಳನ್ನು ತಕ್ಷಣವೇ ಸಮಿತಿಗೆ ಒದಗಿಸಿ ಬೈಠಕ್ ನಡೆಸಿ ವಿಲೇವಾರಿಗೊಳಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳಲು ನಿರ್ದೇಶಿಸಿದೆ. 26. Now can we see annexure A, 4th of December. That is what principal committee lordships have given 2/11. Additional committee is constituted at annexure A, page 29. Karnataka Bhukandaya Adhiniyama 1966 ಅಧಿಕಾರ. ಇಲ್ಲೇ ಬೆಂಗಳೂರು ವಿಧಾನಸಭಾ ಕ್ಷೇತ್ರದ ಹೆಚ್ಚುವರಿ ಬಗರ್ ಹುಕುಂ ಸಾಗುವಳಿ ಸಕ್ರಿಯೀಕರಣ ಸಮಿತಿಯಲ್ಲಿ ಈ ಕೂಡಲೇ ಜಾರಿಗೆ ಬರುವಂತೆ ಮುಂದಿನ ಆದೇಶವನ್ನು ತಿಳಿಸಿದೆ. Who is the chairman? The member who lost the election
in the previous assembly constitutional LSC. I don't, number of cases what's going to end is, I am filing this memo. What's going to end is, as how the cases are divided between these committees.
Who is the person who is? Which is that additional committee?
I mean, annexure
Annexure A.
Oh, wait, wait. Three.
Pradeep Kumar. Annexure F is also same. Ananta. Movadi. Savitri.
Annexure F is
Alvagadde.
annexure to the principal. 2011-2023 principal committee MLA as the chairman. Within 1 month additional committee repeated MLA as the chairman.
Yeah, I'm finding the same names here in Annexure A also.
And election, yeah.
ಎರಡು ಒಂದೇ ಇದೆ.
ಗುರುರಾಜ್ ಗಂಟಿ.
ಹೌದೇ ಸೇಮ್ ಅದೇನೆ.
ಗೋಪಾಲ್ ಪೂಜಾರಿ.
ಹಾ?
ಗೋಪಾಲ್ ಪೂಜಾರಿ.
ಏನಪ್ಪ ನಂದ್ರಲ್ಲಿ ಆತರ ಇಲ್ಲ.
ಸಾರಿ. State. What is server on them? Make sure he consists with next passing. Yeah, quite the same. Yeah, quite the same one. This is what is the. I'll just file it down. Section E what is what now has been passed on. The board. Gopal Pujari, 26. Now this is how much 94 subsection 2 is exercised with the state. The 94(2) requires what you have just said. You shall constitute a principal committee, but for the purpose of additional committee, you shall record reasons as to why it is necessary. If it's no, that is not the mandate of the legislature. This is not discretion given to the state government responsibility. It cannot be constituted so casually without any justification. But this memo is process now see.
ಏನಾಗಿದೆ? What is the problem now?
No, the difficulty is this constitution of both committees.
Huh.
All our applications have been transferred to the additional committee.
Huh.
And this method towards by which additional committee has been constituted without recording any reasons is called into question.
But why you want your applications to be considered, isn't it?
But the fact not that our committee, but our applications were pending for the principal committee. What is called into question? That when a power is vested in the state government, we exercise powers in the manner provided there.
All right.
Failure to do so.
Let them answer then.
Yes.
Then, of course, I will record.
I will type around the memo.
Learned AGA. Take notice for response number 1 to 3. Notice to response number 4 to 7. Learned counsel for petitioner is directed to serve a copy of the petition along with the annexure from the learned AGA. Next para. Learned senior counsel Sri Prabhuling Navati, appearing on behalf of the petitioners, submits that by inadvertence, annexure A should have been the impugned notification dated 4/12/2023. Is not filed. And on the other hand, the previous notification dated 2/11/23 has been filed. Full stop. Learned senior counsel would therefore seek leave of this court to replace
Fresh petition.
replace annexure A with the correct document, which is notification dated 4/12/2023, which has been impugned in this writ petition. Full stop. Leave is granted. Since what interim prayer?
We are seeking not, let them not take final decisions.
Yake, why? What is the problem?
This. But this, the whole idea is to frustrate the functions of the principal committee. It's quite clear now from the order.
No, but what is the problem? You are all applicants, isn't it?
I'm not this principal committee, but the member of the legislative assembly being named the chairman. Never been considered there. The way it gets transferred to the deputy commissioner, practically keeping no one for the principal. The entire matter is transferred to the additional.
So
there is
what is the real grievance of the petitioners?
Grievance is what we want to be treated fairly by the principal committee. You know what, I would at this stage request, let them not come back, so the justification is
All right.
they have constituted the election.
Since the petitioners who are applicants who have filed form number 57,
Yes,
53 before the Committee for Regularization of Unauthorized Occupation are calling in question the impugned notification dated 4/12/2023, by virtue of which an additional committee has been constituted for Udupi district, for Baindur Taluk. It should be Taluk.
Assembly constituency, 94 area.
Huh?
Committees for legislative assembly constituency.
Baindur assembly segment, the learned AGA is directed to bring to the notice of the learned Advocate General the matter and ensure that instructions are secured and if necessary statement of objections be filed at the earliest. We'll stop. Release this matter on 27th of February.
Another request. We have made the chairman and other members as parties, I don't think they are necessary. Second, 4th, 5th, 6th, and 7th. Permit us to not dispense notice to them or permit us to delete them. They have parties. The chairman and the members of the additional committee have been parties.
No. I think it is. It will be proper. Yakandre, tomorrow they will say we were not heard.
Then what's the issue? Right, shows of notice 4, 5, 6, 7.
I have sorted it. Ian, what is this you have filed?
So this is the memo words by which cases have been transferred. Lordship may kindly take note. How cases have been bifurcated between the committees.
Allah, ನೀವು ಅಲ್ಲಿ ಇದರಲ್ಲೇ ಹಾಕ್ಬಿಡಿ ಆಫೀಸಲ್ಲಿ so that you will get acknowledgement for having filed it. Mic mute ಆಗಿದೆ.
Waiting for petitioner lordship, prays for a week time to do the needful.
A week's time is granted at the request of learned counsel for petitioner. For taking steps for service of notice on respond number 4A. Huh? You are given a copy of the. Yeah. Huh? You are directed to secure copy of the circular dated 23/4/2005, which has been referred to in condition 4 of the impugned order passed by the deputy commissioner. Huh?
It's another 25 years, that is the only my grievance.
Huh. Huh?
Some cases they are within limits of. Some a lot.
Yeah, you didn't get it. But this rule is not amended. But they have imposed a condition of non-alienation for 25 years. If the rule is not amended, how can you impose the condition? The notification issued on 23/4/2005 is only that 34 rule 1 rule I 108. amend ಆಗಿದೆಯಲ್ಲ ರೂಲ್ಸ್ with effect from 25/8/2011 ರೂಲ್ ಅಮೆಂಡ್ ಆಗಿದೆ 108J. Huh? This was issued on 21/11/2013. Huh.
The grant was made under the casual South Canada district lease of land for casual rental. Rule 1957. Initially for 30 years, the lease was granted. After expiry of 30 years, then it will be conferred on him on ownership basis.
Rule 2 read with Rule 5 of the South Canada District Lease of Land for Casual Cultivation Rules 1957. Huh.
Same condition in that.
The contention is these rules cannot be applied.
Cannot be applied to the grant.
2016 matter. Filed objection. ಬರ್ಕೊಳ್ಳಿ. The contention of the petitioner is that the land in question measuring 1 acre 3 cents in survey number 60/A of Bandar village, Udupi Taluk was granted on lease to the petitioner's father, late Sri Krishnappa Shetty, on 15/8/1958 in terms of the provisions contained in the South Canara District Lease of Lands for cashew nut cultivation, rules, 1957. Start ಮಾಡಬಹುದು.
Contention of the petitioner is that land in question.
So, it is contended that in terms of the provisions of the said rules, after the expiry of the period of 30 years lease, option is available to the lessee to acquire permanent ownership of the land after expiry of 30 years, on payment of value of the land fixed at the time of grant itself. So, accordingly, at the request of the petitioner, the Deputy Commissioner, Udupi District has passed the impugned order dated 21/11/2013 at Annexure A. Permanently granting the land to the petitioner. So, however, the Deputy Commissioner has referred to a circular dated 23/4/2005, at condition number 4, and accordingly, a non-alienation clause of 25 years has been imposed in the grant. So, Learned Counsel submits that in terms of the rules, 1957, which are applicable to the facts of the case, since 30 years lease period have expired and thereafter a permanent grant order is passed, there cannot be imposition of non-alienation condition. Full stop. It is contended that the circular mentioned in condition number 4 cannot be made applicable to the facts and circumstances of this case and the grant made in terms of the rules, 1957. So, next para. This petition was filed on 24th of May 2016, and till date, statement of objections have not been filed by the respondents. Full stop. Next para. Nevertheless, at the request of learned AGA, release this matter on 20th of February 2024 to enable the learned AGA to secure instructions and make submission. Yes.
Let us go down.
Or ನಿಮ್ಮ petition ಅಲ್ಲಿ ಏನು what is the note? Memo dated 25/1/2024 for petitioners.
The petitioner's petition does not indicate. But no was filed to. And in respect of that particular survey number. In the correct petition is related to survey number 95, not survey number 49 in respect of which we are seeking, 120 in respect of which we are seeking for amendment.
ಅದನ್ನ ಇವಾಗ ನೋಟ್ ಮಾಡಿದ್ರೆ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ. It matter to be disposed of now, 2017 year. Who had filed the suit? learned counsel, Shri Sharath S. Gowda, submits that he would undertake to appear for response number 4 to 7 and 9 to 12 in the connected writ petition number 4778 of 2017. So, the learned counsel would also submit that respondent number 8 in the said writ petition is no more. So, however, the legal representatives of deceased respondent number 8 are already on record. So, similarly, respondent number 3 is also no more, but the legal representatives are already on record. Full stop. A week's time is granted to the learned counsel to file wakalat. So, office is directed to show the name of learned counsel, Sri Sharath S. Gowda, for the said respondents in the cause list. Full stop. Next para. Learned counsel for the petitioners in the connected writ petition submits that a suit was filed. A suit was filed by some of the family members seeking partition and separate possession. So, in that regard, a regular first appeal number is pending consideration before this court. Full stop. Learned counsel is required to give the details of the proceedings. Full stop. And serve a copy of the same on the learned counsel for the contesting respondents. So, ಆಯ್ತು ಅವ್ರು ಕೊಡ್ಲಿ, ನೀವು ನೋಡಿ, they can make submission. Release this matter on 27th of February. All right. ಯಾರು 7 in the first petition. Mr. Jayaprakash's name is shown. The WP number 465509 of 2017. Ms. Sheetal Borkar is said to have filed NOC wakalat on behalf of respondent number 7. It's not filed, is it?
Name of submitted. Ms. Sheetal also is said to have filed NOC wakalat.
Is seeking to file NOC wakalat on behalf of respondent number 7. Full stop. If such wakalat is filed in the office, office shall take note of the same and show the name of the learned counsel in the cause list. Sir, office ko put. Yes. Learned counsel for petitioner has filed a memo dated 8/2/2024. Petitioner. Why you have not signed it? A petitioner. the petitioner, Sri S.N. Ramesh, has filed a memo dated 8/2/2024 stating that he does not wish to prosecute the writ petition any further. So, in fact, he had requested the learned counsel on record to file such a memo seeking leave of this court to withdraw the writ petition. However, the learned counsel did not file such a memo, and therefore the petitioner is constrained to file the memo. So, memo is taken on record subject to all just exceptions. Accordingly, the writ petition stands dismissed as withdrawn. Huh? Finally, a week's time is granted at the request of learned counsel for petitioner for taking steps for service of notice on respondent number 3. Huh? Huh? Yes. Huh? 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 Pending. Then there is it would amount to contempt. You want it to court to take action, we will take action. Huh? No. It was for the chief secretary to have made a communication, requested some time if they were not able to comply with the direction. Yenu madilla. In spite of this court again reminding you, you are still saying we do not know. Then we will direct the matter to be taken up on the contempt side. ಟೈಮ್ ಆಗೋಯ್ತಲ್ಲ. ಹೈಕೋರ್ಟ್ ಕಂಟೆಂಪ್ಟ್ ಪಿಟಿಷನ್ ಇದು ಕಂಟೆಂಪ್ಟ್ಸ್ ಆಫ್ ಕೋರ್ಟ್ ಹಾಕ್ಬಿಡಿ. Objection. On the previous date of hearing, that is 6/2/2024. This court had passed the following order, extract. Today, the learned AGA submits that the matter is still pending consideration before the government. Full stop. This court finds that the Chief Secretary, Government of Karnataka, has not responded to the directions issued by this court. Stop. No communication is made by the Chief Secretary. To state as to what is the steps taken by the Chief Secretary consequent to the orders passed by this court on 31st of August 2023. Stop. Action taken report was required to have been filed within a period of 3 months from the date of receipt of a copy of the order of this court. Stop. Prima facie, therefore, the non-compliance of the directions issued by this court would amount to contempt. Stop. Alappa, they have not even given anything in writing to say what steps have been taken. If they think that it's all right, nothing will happen. At this juncture, even at ATA, fervently requests the court to grant a week's time to enable the Chief Secretary to furnish the action taken report. That's all. Next paragraph. Release this matter on 20th of February 2024.
My lords, I appear for the petitioner, my lords.
Yes.
My lords, I pray for 2 weeks' time, my lords.
ಏನಮ್ಮ ಡೆಫಿಸಿಟ್ ಕೋರ್ಟ್ ಫೀ ₹200 ಕಟ್ಟೋದಕ್ಕೆ 2 ವಾರ ಟೈಮ್ ಬೇಕಾ ನಿಮ್ಗೆ?
ಸರ್ ಇಲ್ಲ ಮಾಡ್ತೀವಿ ಸರ್, ಇವತ್ತೇ ಮಾಡ್ತೀವಿ ಸರ್. ಕಂಪ್ಲೇಂಟ್ಸ್ ಇದು ಮಾಡಿದ್ದೆ.
ಏನ್ರಿ ಇದು ಭಾನುಪ್ರಕಾಶ್ ಮತ್ತೆ ಮಲ್ಲಾರ್ ರಾವ್?
ಎಸ್ ಮೈ ಲಾರ್ಡ್ಸ್.
ಭಾನುಪ್ರಕಾಶ್ ಏನ್ ಸ್ಟೇಟ್ ಏನಿತ್ತು? LR matter. But how can they file it in the name of ಈಗ 2023?
ಮೈ ಲಾರ್ಡ್ಸ್ ಅದು ಭಾನುಪ್ರಕಾಶ್ ಸರ್ದು, ಮೈ ಲಾರ್ಡ್ಸ್ ಮಲ್ಲಾರಾವ್ ಸರ್ದಲ್ಲ.
Prakash is not the learned additional advocate general.
My lords, Bhanuprakash sir is the advocate on record, my lords, not the.
He is not the additional advocate general.
No, my lords, no, my lords.
Learned counsel for the petitioner submits that the deficit court fee will be paid during the course of the day or by tomorrow.
Yes, my lords. Much obliged, my lords.
The deficit court fee is paid and office objections are complied, list this matter for preliminary hearing on 19th of February.
Much obliged, my lords.
Appear for respondent number 6 and 7, my lord. Appear for respondent number 6 and 7, my lord.
Non-filing of wakalat on behalf of respondent number 3 by advocate for respondent number 6 and 7.
In fact, we have in fact intimated our client, my lord. They are not engaged me. Probably they are engaging some other advocate, I think, my lord. ಹೇಳಿ ಕಳಿಸಿದ್ರಿ, ಅವ್ರು ಇನ್ನೂ ವಕಾಲತ್ ಕೊಟ್ಟಿಲ್ಲ ಸರ್. Keep it with you. Yes.
As per annexure B, 1 acre 6 kutas have been re-granted on 15/1/1974. Thereafter, by virtue of the sale deed dated 17/1/1971 annexure C, yellow parcels 10 kutas of land. Remaining
Marappa and Munishamappa jointly executed sale deed. ಇದು ರಿಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 311 ತಾನೆ? ನಿಮ್ಮ ಸಿನಾಪ್ಸಿಸ್ ಅಲ್ಲಿ ಆತರ ಹೇಳಿದಿರ ನೀವು?
That's what you mentioned and unnecessary. The fact remains, my lord, as per annexure B, he get 1 acre 6 gunters.
ಯಾರು?
Free granted, Yellappa.
ಎಲ್ಲಪ್ಪ?
Other than grandfather in petitions. Yes, please, you know, kindly take the state of the. Fine, my lord.
ಹಾ,
20 page 26, my lord. Vadagale, color and not color 3, my lord, Yellappa gets 1 acre 6 gunters.
ಹಾ,
1 acre 6 gunters. Based on that title, my lord, this is on, date is going for, my lord, this is 15/4/1974.
Ah. ಹಾ,
And then my lord, on 17/1/1975, at page 33, my lord,
ಹಾ,
it's a 10 gunters. Type copies and 33, page 32 and 33. At 33, my lord, Rockford outline.
ಚೌಡಾರೆಡ್ಡಿ
Unsensitive totality.
10 ಗುಂಟಾಸ್.
10.
ಹಾ,
124 ಪೈಕಿ ಸೃಷ್ಟಿ ವಿಸ್ತೀರ್ಣ 10 ಗುಂಟೆಗೆ ಆ ತರ ಆಗುತ್ತೆ.
ಹಾ. ಹಾ,
Now, my lord, there was a disturbance and they tried to encroach upon my property, the remaining 36 gunta.
ಹಾ,
He filed a suit in, after annexure, yes, my lord, position number 10.
what is the annexure D? There is one more sale deed.
That is executed by someone, that is the adjacent land executed by Marappa and.
Ah.
That is what nothing to be.
ಆಯ್ತು,
My property.
ಸರಿ.
And that sale deed has been brought to the notice of me in, this one was filed, suit was filed. A return statement was filed on 20th July 2021. Here they said there is an order of Tahsildar granting them 2 acres 7 gunta. Total extent one, survey number 124 was available, is only 1 acre 5 guntas in favor of Marappa, 1 acre 6 guntas in favor of Yellappa.
Hmm.
In terms of the original order, we granted 15/4/1974.
ಹಾ,
Thereafter, without any notice, annexure A has been passed by the Tahsildar at page 21.
this is survey number 124. 124 ಅಲ್ಲಿ ಚಿಕ್ಕಬಸಪ್ಪ was granted 2 acres 10 guntas, Marappa was granted 1 acre 5 guntas, Yellappa was granted 1 acre 6 guntas. ಹಾ,
In that 1 acre scooter,
Ah.
10 guntas.
ಹಾ.
Remaining 36 scooters are there with me. Now, when that was disturbed.
You are claiming through Yellappa.
Yellappa's children.
Ah.
It's a near country of the land.
Ah.
And we are in possession.
Ah.
And when they try to encroach upon, build something on the property, then we approach the civil court.
Hmm.
And thereafter, return statement came to be filed after annexure C on 20th July 2021. There they narrated that our land has been granted to them by Tahsildar as per annexure A.
Annexure?
A, page 21 is the type of the order. They just refer to the judgment where the theme of it is that when the property is sold, then it will endure to the benefit of the purchaser.
Pertains to Neerganti lands re-granted by Assistant Commissioner to the Baravardars, Chikkadasappa, Marappa and Yellappa, who are the holders. Chowdareddy has purchased lands from these grantees in survey number 124. Extent 2 acres 11 guntas. Earlier to 1971, Chowdareddy position for 10 years. Because on the
I am not a party in to annexure A, my land, property which belongs to me cannot be stripped of me without hearing me or without giving any opportunity to me to explain how exactly I use my property.
We are referring to this order in WP number 18723 of 1979.
That petition either because and then that petition is not challenging the order at annexure B. Annexure B is the order from which I derive title to that property. And because I derive title to that property to the extent of 1 acre 6 meters, out of that 5 have to go there and sell it. Remaining 36 meters are there.
All right.
Now they said because of annexure A, order of the Tahsildar is
Re-granting 2 acres and 11 guntas.
2 acres 11 guntas all got in the in-law property. That's where they take a contention as a written statement.
Allah, but still, even if 2 acres 11 guntas are re-granted, it may be the property which was belonging to Chikkapasappa. 2 acres 10 guntas is over there.
But they don't.
And you are contending that except 10 guntas, no other portion of the property was sold, and you continue to be in possession.
Now they claim that the Marap has 2 acres 10 guntas. Annexure D, they need to produce.
Chikkapasappa to idella 2 acres 10 guntas. Marapa 1 acre 5 guntas.
Marapa 1 acre 5.
Anyway, your contention is Yellappa disposed of only 10 guntas, and the remaining is with you.
But they have purchased 2 acres 1 gunta from Marapa, who was granted only 1 acre 5 gunta. Only extra 4 gunta out of purchase, so the land property put there.
Yes. And what has happened now?
Now they are trying to build something on the property so that they change the nature of the property.
What is the prayer in the writ petition?
If to pass annexure A, because I am not a party to that. Challenging the order of the Tahsildar annexure A. It's a single line order. They say that it refers to the order of the Honorable High Court. And there's as per this order, I am granting the acres 7 gunta. Page 21.
Then they will have to file a statement of this.
My lord, I appear for respondent number 6 and 7, my lord.
Till that time,
But idರಲ್ಲಿ may I submit, my lord?
Change the nature of the process.
My lord, may I submit?
Yes.
My lord, they are challenging the order passed way back in 10/6/1981, my lord, after
Yes,
40 years. And moreover, there is an alternative remedy provided under subsection 2 of section 3 of Karnataka village.
There is actually no need for them to challenge it. Only because you are trying to disturb the possession.
No, my lord, we are in
And
possession.
they say there is a grant order in favor of Yellappa that was passed at annexure B.
Yes, my lord, kindly.
And he has not sold any property to any other person except 10 guntas.
He has sold. Kindly look at annexure E, my lord. This issue has been attained finality.
Annexure E.
Yes, my lord. Chowda Reddy, who is the purchaser, my lord, and eviction notice was issued after regrant, my lord. Before regrant, only purchased 2 acre 1 guntas from both.
That is what he pointed out, sir. These people are not parties to that proceedings.
My lord, the Honorable High Court has ordered for regularizing the land by collecting the fees, my lord.
Sir, he is saying I am not a party to those proceedings.
My lord, it's almost finalized. They should have challenged this writ petition, my lord.
No.
Writ petition has
He
become.
is not a party to the proceedings, sir. He is saying I came to know only when this information was given in the written statement.
No, my lord. From thereafter, RTC was mutated in the name of the respondents.
The contesting respondents
are in possession.
Private respondents are required to file statement of objection. So, learned counsel for respondent number 4 submits that the statement of objections are ready, and a copy is served on the learned counsel for petitioner.
2 weeks may be time granted for me to file objections also.
2 weeks are granted at the request of learned counsel for response number
6 and 7, my lord.
6 and 7 to file statement of objection. Full stop. Next para. In the meanwhile, the respondent revenue authorities are directed not to do anything further in respect of the revenue entries of the land in question until specific orders are passed by this court.
They will not build anything.
My lord, they are in possession. The RTC shows that we are in
We are
possession.
not concerned with all that. We are only concerned with the revenue entries.
40 years. Mutation and unnecessarily agide. Again, partition has taken place between the family members, my lord.
Date ಏನಿಲ್ಲ.
ನಿಮ್ದು ಎಲ್ಲಿ ಮೇಡಮ್? ಕೂಲ ಎಲ್ಲ 60 ಮೆಮೊ ಬಂದಿದೆ, 60 ಮೆಮೊ ಕೊಟ್ಟಿದ್ದೀವಿ. 59 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದೀವಿ. ಇಪ್ಪತ್ತೊಂದಿಲ್ಲ
ಇದೆ ಇಲ್ಲ ಅಂದ್ರೆ ಓದಿ ಅಷ್ಟೇ. ನನ್ನ ಇಷ್ಟೇ
ಸರಿ ಕೇಳ್ಬಾರ್ದು. ಇನ್ನೊಂದ್ ಸಲ ಹೋಗ್ಬೇಕು ಸರ್.
ಈಗ ಮಾತ್ರ ಪಡಿತೀನಿ ನಾನು. ಎಲ್ಲರೂ ಕೊಡ್ತೀನಿ. ಇವಾಗ ಎಲ್ಲ 16 ಡೇಟ್ ಸುಮ್ಮನೆ ನೀವೇ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ನಾಳೆ ಡೇಟ್ ಹಾಕಿದ್ದೀನಿ. ಇವಾಗ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ನಾಳೆ ಡೇಟ್ ಹಾಕಿದ್ದೀನಿ. ಎಲ್ಲದೂ ಇಲ್ಲ ಏನ್ ಕೊಟ್ಟು ನೈನ್ಟೀನ್ ಮೇಲೆ ಡೇಟ್ ಅಂದ್ರೆ ಇಲ್ಲ ಹೋಗಿದೆ. ಗಾಡಿಯಲ್ಲೂ ಹೋಗಿದೆ. ಇದಾದ್ರೆ ಬರಲಿಲ್ಲ.
ಏನ್ ಮಾಡ್ತಾರೆ ಜೀವನ ಕರ್ಕೊಂಡು
ಹೋಗಿಲ್ಲ.
ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾರೆ ಎಲ್ಲ ಇದ್ದವ್ರ ಮೇಲೆ ಕೋರ್ಟ್ ಹೇಳಿದೆ. ಹೌದಾ
100% ಹೋಗೋದು ಈಗ ಸ್ಟಾಂಪ್ ಈಗ ಮನೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಇಷ್ಟು ಹೇಳಿದ್ರೆ ಇನ್ನೇನು ರೀಚ್ ಆಗಿ ಫೈರ್ ಶುರುವಾಯ್ತು ಇವತ್ತು ಬಂದ ಶುರುವಾಯ್ತು ಸರಿ ಇದೆಲ್ಲ ಏನು ಅಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ ಬಂದ್ಕೊಡೋದು 3 ಜನ ಏನ್ ಮಾಡೋದು
Court of four.
Huh? Huh? Who is on the other side? Only advocates, only government advocate. Huh? Real number? Number 41. At the request of learned counsel for petitioner. Release this matter. Huh? Why? Huh? He can't give you a date which you are requesting. 20th of January, February. Yes.
For respondent number 3 and 4.
AAT. Land reforms matter. What is it?
Land reforms, land revenue.
Ah.
The order is PAT that because the third and fourth resolutions are challenged, the land conversion order which was granted in my favor, so filing an appeal before the court. Not land reforms.
Right.
But I just give 2 dates for it. But I purchased the land, this is land within 725 or 2 blocks. So that they relation. About 4 acres, 19 cents.
Yes.
But the purchase was on 20th of June 2019. Thereafter, I filed an application seeking conversion of the land into 2 portions, 89 cents for commercial purpose and 3 acres, 25 cents for residential purpose. This is in Kodagu district. That application was filed on 3/8/21. The conversion order came to be passed by the Deputy Commissioner on 4/9/2021 at convention K1. This conversion order came to be challenged by the third and fourth residents who are neighboring landowners. On the ground that because of the conversion and I had also obtained the layout plan for formation of a residential layout units of the residential. That my vendor and I had raised the land to a little higher level, and that would result in the water flow getting clogged, and this land would get flooded, which is for agricultural purpose, because the water would not flow. That I had put up a retaining wall across the land, the boundary. That was the contention raised for challenging the conversion. Now, KRT connection, Q had placed 108 blocks. On an order on 21/8/2023. By recording their contentions and the lords ultimately holding at our 11. That lords, the action towards your lordship should please come to 117 minutes.
Yes.
That the state representative did not address any arguments at page 7. Then para 8 is the consideration of what has happened, and we have contended that the Tahsildar had carried out a survey to find out whether because of this was there water logging or something. Ultimately, the PAT came into the conclusion that the action of me in constructing a retaining wall is not correct, and because of that, there could be flooding of their paddy lands, and set aside the conversion order itself and give some consequential directions. That is what is questioned here. The lordship's outcome, this KAT's order is only that there is no other factual aspect. But what was missed out by the KAT is the important document is one proceedings of the Deputy Commissioner regarding the conversion and complaint, which was on 3/4/2023, which the state did not bring to the authority notice of the KAT, which we have produced before my lord. Please refer to Annex S and page 152.
Yes.
This is of 3/4/2023 ನಡೆದ ಆದೇಶ. ಸಭೆಯನ್ನು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಸಭೆಯಲ್ಲಿ ಹಾಜರಿದ್ದ ಎಲ್ಲರಿಗೂ ಸಭೆಯಲ್ಲಿ ತಮ್ಮ ಪರಿಚಯ ಮಾಡಿಕೊಳ್ಳಲು ತಿಳಿಸಿದ ಮೇರೆಗೆ ಸಭೆಯಲ್ಲಿ ಹಾಜರಿದ್ದ ಎಲ್ಲರೂ ತಮ್ಮ ಪರಿಚಯ ಮಾಡಿಕೊಂಡರು. ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಪ್ರಕರಣ ಕುರಿತು ಸಭೆಗೆ ತಿಳಿಸುವಂತೆ ಮನವಿಗಾರರಿಗೆ ತಿಳಿಸಲಾಗಿ ಸಭೆಯಲ್ಲಿ ಹಾಜರಿದ್ದ ಶ್ರೀ ಕುಮಾರ್ ಎಂಬುವವರು ಮನವಿಗಾರರ ಪರವಾಗಿ ಸಭೆಗೆ ಮಾಹಿತಿ ನೀಡುತ್ತಾ ನಾವು 6-7 ಜನರು ಸುಮಾರು 50-60 ವರ್ಷಗಳಿಂದ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಕೆಳಗಡೆ ಜಮೀನುಗಳಲ್ಲಿ ಕೃಷಿ ಮಾಡಿಕೊಂಡು ಬರುತ್ತಿದ್ದು 2019ರಲ್ಲಿ ಶ್ರೀ ದೀಪಕ್ ಎಂಬುವರು ಮೇಷಣ್ಣ ಮುತ್ತುಬೇರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 35/2 4.199 ಎಕರೆ ಜಮೀನನ್ನು ಖರೀದಿ ಮಾಡಿ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಕೊಂಡು ಲೇಔಟ್ ಮಾಡುತ್ತಿದ್ದಾರೆ. ನಮ್ಮ ಜಮೀನಿನ ಮೇಲೆ ಜಾಗದಲ್ಲಿ ಮಣ್ಣು ಗುಂಟೆ ಹಾಕಿರುವುದರಿಂದ ಮಳೆಗಾಲದಲ್ಲಿ ತೋಡಿನ ನೀರಿನ ಹರಿವಿಗೆ ತೊಂದರೆಯಾಗಿ ನಮ್ಮ ಕೃಷಿ ಭೂಮಿಗಳಲ್ಲಿ ನೀರು ನಿಲ್ಲುತ್ತದೆ. ಇದರಿಂದ ಕೃಷಿ ಚಟುವಟಿಕೆಗಳಿಗೆ ತೊಂದರೆಯಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸರಳಿ ಮಣ್ಣನ್ನು ತೆಗೆಸಿ ನೀರಿನ ಸರಾಗ ಹರಿವಿಗೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟು ನಮ್ಮ ಜಮೀನುಗಳನ್ನು ನೀರು ನಿಲ್ಲದೆ ಮಾಡಿ ಕೃಷಿ ಚಟುವಟಿಕೆಗಳಿಗೆ ಅನುಕೂಲ ಮಾಡಿಕೊಡಬೇಕು ಹಾಗೂ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನ ಲೇಔಟ್ ನಲ್ಲಿ ರಸ್ತೆಯನ್ನು ಪಕ್ಕದಲ್ಲಿ ಈಗಾಗಲೇ ನಿರ್ಮಿಸಿರುವ ತೆರವುಗೊಳಿಸಬೇಕು ಕೋರಿರುತ್ತಾರೆ. ಸಭೆಯನ್ನು ಉದ್ದೇಶಿಸಿ ಮಾತನಾಡಿ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಪ್ರಸ್ತಾಪಿತ ಜಮೀನಿನ ಮಾಲೀಕರು ನಿಯಮಬದ್ಧವಾಗಿ ಭೂ ಪರಿವರ್ತನೆ ಮಾಡಿಕೊಂಡಿರುವುದಾಗಿರುತ್ತದೆ. ಹಾಗೆಯೇ ಮನವಿಗಾರರು ಕೂಡ ತಮ್ಮ ಕೃಷಿ ಭೂಮಿಯಲ್ಲಿ ಮಳೆಗಾಲದಲ್ಲಿ ನೀರು ನಿಲ್ಲುತ್ತಿರುವುದರಿಂದ ಕೃಷಿ ಚಟುವಟಿಕೆಗಳಿಗೆ ತೊಂದರೆ ಅನುಭವಿಸುವುದಾಗಿರುತ್ತದೆ. ಲೇಔಟ್ ಪಕ್ಕದಲ್ಲಿರುವ ತೋಡಿಗೆ ನೀರು ಕೃಷಿ ಜಮೀನಿನಲ್ಲಿ ನಿಲ್ಲದಂತೆ ಸರಾಗವಾಗಿ ಹರಿದು ಹೋಗುತ್ತಲ್ಲಿ ಸಮಸ್ಯೆ ಬಗೆ ಹರಿಯುವುದಾಗಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸರ್ವೇಯರ್ಗಳನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿ ತೋಡಿನ ಜಾಗ ಗುರುತು ಮಾಡುವಂತೆ ತಹಸೀಲ್ದಾರ್ ಪೊನ್ನಂಪೇಟೆ ತಾಲೂಕು ಇವರಿಗೆ ತಿಳಿಸಿ ಹಾಗೆಯೇ ನದಿ ಸ್ಥಳ ವಾತಾವರಣವನ್ನು ಪರಾಮರಿಸುವ ಬಗ್ಗೆ ಮಳೆಗಾಲದಲ್ಲಿ ಹೆಚ್ಚು ಮಳೆಯಾಗಿ ತೋಡು ತುಂಬಿ ಹರಿಯುವ ಜುಲೈ ಮಾಹೆಯಲ್ಲಿ ಖುದ್ದು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡುವುದಾಗಿ ತಿಳಿಸಿರುತ್ತಾರೆ. ಹಾಗೆಯೇ ಅಲ್ಲಿಯವರೆಗೆ ತೋಡಿಗೆ ಸಂಬಂಧ ಕೆಲಸವನ್ನು ಬಿಟ್ಟು ಉಳಿದ ಲೇಔಟ್ ಕೆಲಸವನ್ನು ಮಾತ್ರ ಕೈಗೊಳ್ಳುವಂತೆ ಪ್ರಸ್ತಾಪಿತ ಜಮೀನು ಮಾಲೀಕರಿಗೆ ತಿಳಿಸಿದರು. After Lords, the Tahsildar, the survey report was conducted Lord, and the survey report came to be issued on 19/4/2023 by the Revenue Inspector and Tahsildar, which your Lordship should get a connection to 155 is not the handwritten one, 156 is the type copy.
Yes.
Physics your Lordship. ಉಡುಪಿಯಲ್ಲಿ ಹೋಗಿ ಮುಗರಿಯಲ್ಲಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 35/2ರಲ್ಲಿ 4 ಎಕರೆ 19 ಎಕರೆ ಕೃಷಿಯೇತರ ಜಮೀನಿನ ಪಕ್ಕದಲ್ಲಿ ಇರುವ ತೋಪು ಅಂತ ಬಂದಿದೆ. ಆಕ್ಚುಲಿ ಬಂದಿರೋ ತೋಡು ಟೈಪಿಂಗ್ ಅಲ್ಲಿ ತೋಪು ಅಂತ ಬಂದಿದೆ. ತೋಡು ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆಯೊಂದಿಗೆ ವರದಿ ನೀಡಲು ನಿಮ್ಮ ಕಚೇರಿಯಿಂದ ಸಂಖ್ಯೆ ನಂಬರ್ ದಿನಾಂಕ 5/4/23 ಮತ್ತೆ ತಾಲೂಕು ಭೂ ಮಾಪಕರು ಸರ್ವೆ ಕಾರ್ಯ ನಡೆಸಿ ನಕ್ಷೆಯೊಂದಿಗೆ ವರದಿ ನೀಡಿರುತ್ತಾರೆ. ಅದರಂತೆ ಪರಿಶೀಲಿಸಲಾಗಿ ತಾಲೂಕು ಭೂ ಮಾಪಕರು ಸಲ್ಲಿಸಿದ ಸರ್ವೆ ನಕ್ಷೆಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 36/1ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ತೋಟು ಚಿಕ್ಕ ಗಿಡಗಳು ಮತ್ತು ಹುಲ್ಲುಗಳಿಂದ ವೃತ್ತವಾಗಿದ್ದು ನೀರು ಸರಾಗವಾಗಿ ಹರಿಯಲು ಸಾಧ್ಯವಾಗಿರುವುದೆಲ್ಲವೆಂದು ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 35/2 ಮತ್ತು 35/5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ತೋಡಿನ ಒಳಗೆ ಗ್ರಾಮ ಪಂಚಾಯತಿಯವರು ನಿರ್ಮಿಸಲಾದ ರಸ್ತೆ ಇರುತ್ತದೆ ಎಂದು ವರದಿಸಿರುತ್ತಾರೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ ತೋಡಲ್ಲಿ ರಸ್ತೆ ಮಾಡಿದ್ದಾರೆ. ಆದುದರಿಂದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮಲ್ಯಮಂಡೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿಯಿಂದ ನಿರ್ಮಿಸಲಾದ ಕಾಂಕ್ರೀಟ್ ರಸ್ತೆಯನ್ನು ತೆರವುಗೊಳಿಸಿ ಗ್ರಾಮ ನಕ್ಷೆಯನ್ನು ದಾಖಲಿಸುವ ಸರ್ಕಾರಿ ತೋಡಿನಲ್ಲಿ ನೀರು ಸರಾಗವಾಗಿ ಹರಿಯುವಂತೆ ವ್ಯವಸ್ಥೆ ಮಾಡುವ ಬಗ್ಗೆ ಮಲ್ಯಮಂಡೂರು ಗ್ರಾಮ ಪಂಚಾಯತಿ ಅಭಿವೃದ್ಧಿ ಅಧಿಕಾರಿಗಳಿಗೆ ತಿಳುವಳಿಕೆ ಪತ್ರ ನೀಡಲು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಜರುಗಿಸಿದೆ. This is the finding which was given below. Thereafter,
have you furnished any photograph?
Of the land, there is photograph of what I have done. But so far as Kodu, the village map shows, if you watch it, just.
If you have got photographs, you please show the photograph.
Yes, sir. One photograph, but that is not so, at least up to page 60. And after the photos, it is
If you have photographs, you please show.
One photo is there. This is how the land is, my photograph. But, photo on the outer block of the. The first photograph, if your lordships are seeing now. Left side is my property, right side is the third and fourth correspondence property. So far as my lords, there is no property dispute regarding anything else. It's only the issue of flooding of water. Then my lords, the second photograph at page 3 is another angle which shows. Land to non-land.
ನಿಮ್ಮ ಇಬ್ಬರ ಲ್ಯಾಂಡ್ ಮಧ್ಯ there is a
ನಮ್ಮ ಲ್ಯಾಂಡ್ ಮಧ್ಯ ಇಲ್ಲ.
ಅಲ್ಲಲ್ಲ
Cycle ಹೋಗುತ್ತೆ.
ನಿಮ್ಮ ಇಬ್ಬರ ಲ್ಯಾಂಡ್ ಮಧ್ಯದಲ್ಲಿ there is
That is the.
a waterway.
No,
Huh?
that is, there is no waterway in between our land.
Then what is this photograph?
But that is their land.
ಈ ಕಡೆ ಇರೋದು ನಿಮ್ದು.
ಅದು ನನ್ನ land.
ಈ ಕಡೆ ಇರೋದು
ಅದು ಅವ್ರ land.
What is this water?
ಇದು. ಅದ್ರದ್ದು ನೆರಳು ಅಂತ ಇವರು ಹೇಳೋದು.
ಅಲ್ಲ ನೆರಳು ಇದೆ ಬಟ್ ವೈ ಬಿಕಾಸ್ ಹಿಯರ್ ದೇ ಹ್ಯಾವ್ ಕ್ರಿಯೇಟೆಡ್ ಅನ್ ಆಕ್ಸೆಸ್.
ಅಲ್ಲೊಂದು ಬ್ರಿಡ್ಜ್ ಇದೆ. But the
Which
problem
means
is, yes.
water was flowing like this.
ಅಲ್ಲಿ ಅದು ಬ್ಲಾಕ್ ಆಗತ್ತೆ ಅಂತ ಅವ್ರು ಹೇಳಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ಏನು ಅಂದ್ರೆ that I should not construct this retaining wall itself. But I have to guard my property. If I guard and I have raised the level of my land records for the purposes of conversion. Once I have got conversion. Their complaint is I should remove this retaining wall because their contention is the water from their land should flow into my land and flow out into the Nala. Now, the village map shows the actual position. If your lordship sees the total, and the problem is the Gram Panchayat Lord says.
ಏನು ತೋಡು ಅಂದ್ರೆ ಏನು?
Lords, that's a stream. ಅಲ್ಲಿ ನೀರು ಹರಿಯಕ್ಕೆ ಜಾಗ ಇರುತ್ತೆ.
Which means there was a nala.
ಅದಿದೆ ಅದು ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ.
ಎಲ್ಲಿ ರೋಡ್ ಮಾಡಿದ್ದಾರೆ?
That's the finding given in the sir. I read. Thereafter,
you will have to point out from the photograph, sir. What is that?
Friends, that is the other side. Other side ಇಲ್ಲಿ ನಾವು ಇಲ್ಲಿ ಬಂದ್ರೆ page 60 ಬನ್ನಿ read petition. 60. But 60 left side ಇದೆಯಲ್ಲ ಅದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ. ಅದು ಹಿಂದ್ಗಡೆ ಇವ್ರದ್ದು ಬರುತ್ತೆ. ಈ ರೋಡ್ ಹತ್ರ ಕಾಣುತ್ತಲ್ಲ that entire thing ತೋಡನ್ನ ಕಾಂಕ್ರೀಟ್ ಹಾಕಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಗ್ರಾಮ ಪಂಚಾಯತಿ says I am not done it. The Jilla Panchayat has done it. That is the survey finding which says if this road is removed, it goes again to the main road. Sorry, it's very diagonal. That is the main road. So this goes, touches there and flows. The water is to flow there, but Panchayat have made a road. Otherwise, the water would flow in this next to my land, next to his land, it would go out only during the rainy season.
Left side ಇರೋದು ನಿಮ್ಮ ಪ್ರಾಪರ್ಟಿ.
ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ.
ರೈಟ್ ಸೈಡ್ ಇರೋದು ಅವ್ರ ಪ್ರಾಪರ್ಟಿ.
ಹೌದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ. ಹೌದು ಲೆಫ್ಟ್ ಸೈಡ್ ಅಲ್ಲೇ ಬರುತ್ತೆ, ಹಿಂದ್ಗಡೆ ಬರುತ್ತೆ.
ಟುವರ್ಡ್ಸ್ ದಟ್ ರೋಡ್ ಆ ಕಡೆ ಬರುತ್ತೆ.
ಈ ಹಿಂದೆ ಇಲ್ಲಿ
ಈ ಸೈಡ್ಗೆ
ಈ ಕಡೆಗೆ ಬರುತ್ತೆ. ಇದು ದಿಸ್ ಎಂಟೈರ್ ಥಿಂಗ್ ವಾಸ್ ಎ ತೋಡು. ಅದು ಅಲ್ಲಿ ಕಾಂಕ್ರೀಟ್ ಮಾಡಿ ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಪಂಚಾಯತಿ. But otherwise the water would flow from my land, his land into this todu and go out. ಅಲ್ಲಿ ಮುಂದೆ ಮೋರಿಗೆ ಹೊರಟೋಗುತ್ತೆ. ಅವರು ರೋಡ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. That's why not every only during the heavy rainy season it gets flooded. Now that is why the Tahsildar and the revenue officials found that this todu has to be done. Sorry, the road has to be removed. ಇಲ್ಲಿ ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಜಾಗ ಇದೆ ಅಷ್ಟೇ. Village map if your lordship sees. But not marked. It's almost in the left hand side in the second one, 35 of the Karnataka. But in the left hand side, 35. 35 ಮಧ್ಯೆ ಎರಡು ಲೈನ್ ಹೋಗುತ್ತೆ. ಇವೆರಡೂ ತೋಡು. Surrounded by toad, steel ತರ ಕಾಣುತ್ತೆ, but it is toad. One is blocked completely. Because of the road formed by the Panchayat. ಮೇಲ್ಗಡೆ ಇರೋದು 35/1 ಇವ್ರದ್ದು.
ಕೆಳಗಡೆ ಇರೋದು ನಮ್ದು 35/2. Big portion of this. 35/1 ಅಂತ ಇದೆ. ಅದು ಅವ್ರ ಪ್ರಾಪರ್ಟಿ, 3rd and 4th response. ಅದ್ರ ಕೆಳಗಡೆ 35/2 ಅಂತ. ಅದು ನಮ್ಮ ಪ್ರಾಪರ್ಟಿ. ಎಲ್ಲಾ ಪ್ರಾಪರ್ಟಿ ಕೊಟ್ಟರು ಕೊಡೋದು. ಇಲ್ಲಿ ಲೆಫ್ಟ್ ಸೈಡ್ ಇಲ್ಲಿ ಗಿಡ ಮರ ಇದೆ, ಇದು ಬ್ಲಾಕ್ ಆಗಿದೆ, ಇದು ರೋಡ್ ಮಾಡಿಬಿಟ್ಟಿದೆ. That is what the survey found in. That is also further. It was further action was taken on that, which I read to my lord's survey report. Then please come, lords, to annexure W at page 160. Sketch 159 ಅಲ್ಲಿ ಇದೆ. 159 ಅಲ್ಲಿ ಅದೇ ಸ್ಕೆಚ್ ಕಾಣುತ್ತೆ. ಮಾರ್ಕ್ ಆಗಿರೋದು. ಈ ರೋಡ್ ಮಾಡಿರೋದು ಇಲ್ಲಿ ಡಾರ್ಕ್ ಆಗಿ ಬಂದ್ಬಿಟ್ಟಿದೆ. That's what they record. The ಗ್ರಾಮ ಪಂಚಾಯತಿ ಮಾಡಿದ್ದಾರೆ ಈ ಕೆಲಸ. ಈ ಬಣ್ಣದಲ್ಲಿ ತೋರಿಸಿರುವ
35/5, 35/2.
35/2 ಬಂದು 35/1 ಹೌದು. 35/5 ಮೈನ್.
35/1 ಎಲ್ಲಿದೆ ಇಲ್ಲಿ?
ಮೇಲ್ಗಡೆ 35/5 ಮೇಲ್ಗಡೆ ಒಂದು 35
ಆ ಕಡೆ ಇದೆ.
ಹೌದು ಅವ್ರದ್ದು. ಬಟ್ so far as boundary
36/1 ಕಾಣುತ್ತೆ. 35 ಅದು.
35/1.
35/1.
ಹೌದು 35/1, 35/5 and 35/2 are my lands.
ಎರಡೂನು.
ಅದು ಸ್ಮಾಲ್ ರೆಕ್ಟಾಂಗಲ್ ಇರೋದು ಕಮರ್ಷಿಯಲ್ ಪರ್ಪಸ್ ಡಿಮಾರ್ಕೆಟ್ ಆಗಿದೆ. Now on the left side your lordship.
ಅದ್ರ ಪಕ್ಕ ಇರೋದು ರೋಡಾ? 35/2 ಪಕ್ಕ ಇರೋದು ರೋಡಾ?
ಹೌದು ಸ್ಟೇಟ್ ಹೈವೇ. Left side ಒಂದು dark color earlier, right? That is the one which is blocked. That is the road which has been blocked, which has been mentioned that the Gram Panchayati have formed a road. To it, that road, that's actually what they have done. Totally road to main road connect. That is what the sketch says, and please come to 160. Again, it is clarified at 160. Sorry, I'm just saying. Sadri Arata ಕೆಲಸ ಮತ್ತು ಗ್ರಾಮ ನಕಾಶೆ ಅಂತೆ ಆಧಾರವಾಗಿಟ್ಟುಕೊಂಡು ಪೂರೈಸಿದೆ. ಈ ಬಣ್ಣದಲ್ಲಿ ತೋರಿಸಿರುವುದು ಸರ್ವೆ ನಂಬರ್ 35/2 ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 35/5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ತೋಪು ಪ್ರದೇಶವಾಗಿದ್ದು ಯಾವುದೇ ಒತ್ತುವರಿ ಆಗಿರುವುದಿಲ್ಲ. ಈ ಬಣ್ಣದಲ್ಲಿ ತೋರಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ 36/1ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ತೋಪು ಪ್ರದೇಶವಾಗಿದ್ದು ಚಿಕ್ಕ ಚಿಕ್ಕ ಗಿಡಗಳು ಮತ್ತು ಹುಲ್ಲುಗಳಿಂದ ಅವ್ಯಕ್ತವಾಗಿದ್ದು ನೀರು ಸರಾಗವಾಗಿ ಹರಿಯಲು ಸಾಧ್ಯವಾಗಿರುವುದಿಲ್ಲ. ಈ ಬಣ್ಣದಲ್ಲಿ ತೋರಿಸಿರುವುದು ಪಂಚಾಯತಿಗೆ ಸೇರಿದ ಎನ್ನಲಾಗುವ ರಸ್ತೆಯಾಗಿದ್ದು ಸದರಿ ರಸ್ತೆಯು ಸರ್ವೆ ನಂಬರ್ 35/2 ಮತ್ತು 35/5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ರೋಡಿನ ಒಳಗೆ ನಿರ್ಮಿಸಿರುತ್ತಾರೆ. ಸದರಿ ರಸ್ತೆಯು ಹಾಗೆ ಮುಂದುವರಿಯುತ್ತದೆ. ಸದರಿ ಅಳತೆ ಸಮಯದಲ್ಲಿ ಗ್ರಾಮ ಲೆಕ್ಕಾಧಿಕಾರಿಗಳು ಮತ್ತು ಕಂದಾಯ ಪರಿವೀಕ್ಷಕರ ಹಾಜರಿದ್ದು ಅವರ ಸಮಕ್ಷ ರೋಡಿನ ಜಾಗವನ್ನು ಅಳತೆ ಮಾಡಿ ಸ್ಥಳದ ಗುರುತು ಮಾಡಿದೆ. Thereafter, below attachment 161. But the Tahsildar reports the state informing that the road by the GPA Gram Panchayat was obstructing the water flow, which that's on 29/4/2023. 161. Jiladhikari Kardo that the read from the 3rd paragraph in 161. ಅದರ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ರಾಜ್ಯ ನಿರೀಕ್ಷಕರು ಉಡುಕೇರಿ ಹೋಬಳಿ ಅವರಿಂದ ವರದಿ ಪಡೆಯಲಾಗಿರುತ್ತದೆ. ಅವರ ವರದಿಯಂತೆ ಉಡುಕೇರಿ ಹೋಬಳಿ ಮುಸುಗೇರಿ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 35/2 4.19 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ಜಾಗದಲ್ಲಿ ಹರಿಯುತ್ತಿರುವ ರೋಡಿನ ವಿಚಾರದಲ್ಲಿ ಸರ್ವೆ ನಂಬರ್ 36 ರೋಡಿನಲ್ಲಿ ಚಿಕ್ಕ ಚಿಕ್ಕ ಗಿಡಗಳು ಮತ್ತು ಹುಲ್ಲುಗಳಿಂದ ಅವ್ಯಕ್ತವಾಗಿರುತ್ತದೆ. ರೋಡಿನಲ್ಲಿ ನೀರು ಸರಾಗವಾಗಿ ಹರಿಯುವ ಆಗಿರುವುದರಿಂದ ಬಂದು ಹಾಗೂ ಸರ್ವೆ ನಂಬರ್ 35/2 ಮತ್ತು 35/5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಿರುವ ಕೋರ್ಟಿನ ಒಳಗೆ ಗ್ರಾಮ ಪಂಚಾಯತಿ ನಿರ್ಮಿಸಲಾದ ರಸ್ತೆ ಇರುತ್ತದೆ ಎಂದು ವರದಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಉಡುಪಿಯಲ್ಲಿ ಹೋಗಿ ಮುಟ್ಟುಗೆರೆ ಗ್ರಾಮದ ಸರ್ವೆ ನಂಬರ್ 35/2 4.1 ಎಕರೆ ವಿಸ್ತೀರ್ಣದ ಜಾಗವನ್ನು ದಿನಾಂಕ 7/4/23ರಂದು ಖುದ್ದು ಸ್ಥಳ ಪರಿಶೀಲಿಸುತ್ತೇನೆ. ರಾಜ್ಯ ನಿರೀಕ್ಷಕರ ವರದಿ ಮತ್ತು ಸ್ಥಳ ಪರಿಶೀಲನೆಯಂತೆ ಸರ್ವೆ ನಂಬರ್ 36/1ಕ್ಕೆ ಪ್ರದೇಶವನ್ನು ರೋಡಿಗೆ ಹೊಂದಿಕೊಂಡಿದ್ದು ಈ ಪ್ರದೇಶದಲ್ಲಿ ಗಿಡಗಳು ಬೆಳೆದು ನೀರಿನ ಹರಿವಿಗೆ ಅಡಚಣೆಯಾಗಿರುತ್ತದೆ. ಹಾಗೂ 35/2 ಮತ್ತು 35/5ಕ್ಕೆ ಹೊಂದಿಕೊಂಡಂತ ಗ್ರಾಮ ಪಂಚಾಯತಿಯವರು ರೋಡಿನ ಒಳಗಡೆ ಸಿಮೆಂಟ್ ರಸ್ತೆ ನಿರ್ಮಾಣ ಮಾಡಿದೆ. ಈ ಅಂಶವು ಸಹ ನೀರಿನ ಸಹಜ ಹರಿವಿಗೆ ತೊಂದರೆ ಉಂಟು ಮಾಡಿರುವ ಕಾರಣ ಸರ್ವೆ ನಂಬರ್ 35/2 ಹಾಗೂ 35/5ರ ಆಜುಬಾಜಿನಲ್ಲಿರುವ ಗದ್ದೆಗಳಿಗೆ ನೀರು ನಿಲ್ದಾಣ ಕಾರಣವಾಗಿರುತ್ತದೆ ಎಂಬ ಅಂಶಗಳನ್ನು ತಮ್ಮ ಅವಗಣಕ್ಕೆ ಮತ್ತು ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಮೋಜಣಿದಾರಿಗಳ ನಕ್ಷೆ ಮತ್ತು ರಾಜ್ಯದ ನಿರೀಕ್ಷರ ವರದಿ ಸಲ್ಲಿಸುತ್ತೇವೆ. Then what happens is the Tahsildar issues a notice to the Gram Panchayat on 16/6/2020 166 to remove this road and clear the road. Number 166. So that there is a clear water flow.
Who is appearing for the Gram Panchayat?
The Gram Panchayat writes a letter, but it gives a reply on 4/8/23 at annexure AA page 173. Saying it is the Jilla Panchayat which has constructed, I have not constructed. At page 173, annexure AA.
No, for both of them you are appearing. Yes.
Number 21368 of 2023.
What is the dispute there?
The dispute is this very particular issue which we learned in senior council is argued pertaining to this road. Is it subject matter in that?
Yeah, and sold instructions are same. Directions to remove that. This board members directed the Tahsildar to once again conduct an inspection in our
Local bodies matter. Local bodies.
LB at the class, but it can be connected to the because it is Panchayat at the Ali Haq. This one will directed an inspection to be carried out. Now in the inspection he gives findings, but contrary to this, he says because of the retaining wall there is the water is being retained. Now because if the road is clear, everything, my retaining wall, I have a right to put up the retaining wall. Nobody can prevent me from putting up a retaining wall in my.
Let us see the provisions contained in section 95. Or 97?
The version order is 95.
95.
Five. And this problem is being faced only during heavy rains. Now, if the road is clear, the entire problem gets solved. That's the earlier report.
Because the panchayat removes are the Jilla Panchayat removes. One of them have constructed the entire road ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ. ರೋಡ್ ಹೋದ್ರೆ ನಂದು ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ, ಯಾರಿಗೂ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. ನೀರೆಲ್ಲ ಹಾಕೊಂಡು ಹೋಗುತ್ತೆ.
Yes, what do you say?
There is got an impact on others' properties having.
Not only that, sir. How did you form the road?
Again, so as the thing is concerned, whether it is abutting the road or is it?
Not the question of abutting the todu or on the todu or not that. If you have to form a road, you will have to follow due process. How did you form that road? If you have formed that road without authority, it has to be removed. That's it.
And the owner of the property, right, just abutting, let's see, yes,
Yes.
of the learned lady was not only with respect to this wall. The additional problem, and this problem I must highlight, he existed even before the current petitioner purchased the land. So it is not something that has come after the conversion. It has been there since 2019, even before the.
What problem was there?
The lords would see, well, I'll read it directly from the learned lady's order, which is at annexure 2. At page number 108 is annexure 2, the reason started at the.
Page number?
I'll just explain the problem. There's the entire land, starting from the state highway, followed by the petitioner's land, and then about almost 100 acres of agricultural land is sloping downwards towards the state highway. So far as the todu is concerned, it is not one todu. There are 3. One that the learned senior was pointing out to the left of each of all properties. There is a larger todu on the right of the property. And just before the state highway, there is a small drain. Because the amount of water that is flowing down to the agricultural land is not a quantity that can be handled by one way. It should flow down, then it flows into the storm waters and into the river eventually. What has happened, apart, I will not address the point of the road yet, because there is the lots of report. But because of raising the level of the ground by artificially dumping mud, it defeats the natural gradient of the land. Because of which all the water stops up like that. That is one. Second, because of the wall and the land, the natural gradient now being affected, the water does not flow into the drains which are on the right of the property, the left of the property, and straight ahead. So there are 3 of them. Therefore, when the question came up before the KAT's only consideration was, because this problem pre-existed, the letters are on record. 2019, before the property was purchased, one Himaya, who was the predecessor in title, also came and said that he is going to stop this activity putting mud on the property. Eventually, it was purchased by the. When the matter came up before the KAT, an interim order was passed, making detailed findings that the mud and the wall, which was then half constructed, are causing problems in the flow of water. A writ petition was filed before my lords, challenging the interim order there. My lords found that since the detailed order has been passed and the proceedings are ongoing, there is no need for interference. The direction that it should be expeditiously disposed of. The KAT heard both parties and came to the conclusions which are at page number 118, which finds categorically, the Lord's permission and read it. Point number 1, the Lord's permit. The appellant's contention is that the permission for conversion to non-agricultural use was given for the subject land without considering the impact on adjacent land due to the actions that might arise out of such a permission. The appellants have brought on record several representations and complaints made to various authorities, including respondent number 1 about the unilateral action of respondent number 2's vendor. This is predecessor, that's what I meant for. Even before the petitioner came, so 3 existing problems. Dump mud on the subject land even before its sale and subsequent permission to convert to a non-agricultural use. It is evident that the appellant and the other villagers had an issue with the previous and present owners of the subject land, trying to change the contour of the subject land, and the issue has been escalated to the authorities. Natural drainage of water cannot be obstructed by individuals as it would impact the flow of water to nalas, streams, unauthorized blocking of natural drainage. Waste could lead to flooding and damage to adjacent lands.
Given the history of the matter, the respondent number one should have exercised due diligence and verified if natural flow of water would be blocked or obstructed because of the intended non-agricultural use of the subject land. Multiple water bodies have been left destroyed due to the flow of water or such water bodies being cut off by negligent or deliberate means. Mere mention of a condition in the impugned order that the natural state of rivers, canals, streams flowing near the land shall not be changed is not sufficient protection against the wanton destruction of the natural drainage system due to the man-made activities. The least that would be expected is the natural drainage map of the land is superimposed on the map subject land and its environment and specific measures are indicated to safeguard it in order to permit a conversion. The action of the R2 to construct a retaining wall and raising the level of the land by dumping mud is nothing but an attempt to obstruct the natural flow of water. The applicants have submitted photography documentation of the land have been inundated. The right of a person to make profitable use of this land cannot be at the cost of the natural environment and the consequent adverse impact on the livelihood of the adjacent farmers. This, my lord, is a long existing problem, and specifically on the road that is in question, I am not going to whether it is the only cause or not, because that road has been there for 20 years now. And the learned council gave instructions on what
That is why I was trying to pose a question to the learned senior counsel. Whatever has to be done, it has to be done in terms of the provisions contained in section 95.
as well.
Now you please point out from the provisions.
Now, my lords,
What are the preconditions which the deputy commissioner has to look into before passing an order of conversion? So you please point out if there is any provision that is violated, then we will put the same to the
yes,
petitioner. Yes.
the limited purpose of pointing out what we read out now, two things, my lord. One is that the problem being complained of is the leveling of the ground and the what? Second,
Therefore,
is now, my lord, section 95.
yes.
So one thing I will point out, my lord, is that when the conversion order was passed in 2021, subsection 3, 4, 5, and 6 of section 95 are still on the statute. It has been deleted in 2020. Now, my lord, will see subsection 2 of section 95. If any occupant of, with my lord's permission, if any occupant of the land assessed or held for the purpose of agriculture wishes to divert such land or any part thereof to any other purpose, he shall submit an affidavit along with an application to the deputy commissioner in the manner as may be prescribed and if the diversion is sought. I must point out here, the affidavit itself that was submitted for the purpose of anti-application. To the best of my knowledge, has not been useful. So what representations they made to procure this conversion? It's not formal. Now, my lords will see. Subsection 1 to section 2 is an exception which does not apply to arresting period. The permission of the deputy commissioner shall not be required for diversion of
Which one are you reading?
only 1 to subsection 2 of section 9. This, my lord, has been introduced by way of an amendment in 2023, so it won't be directly related to this. So I will skip that. My lord. I will go to subsection 3.
Yes.
Rule 3. If any diversion is obtained with a false or wrong declaration or affidavit under this section, in addition to the criminal liabilities, the same shall be null and void upon order in this regard. That is
Subsection 3.
Roman 3.
Roman
Not
3.
simply having the amended latest version, this is the deleted version which existed.
No, no, if that is not applicable, you can't read that.
That's right.
Yes.
Now, what was required to be stated in the affidavit as to how there are no violations and in fact conditions in the permission granted itself. And my lord will now see the impugned conversion order, which is at page 55. Annexure K.
So you are not able to point out to any particular provision.
Please. I will point out.
Please point out first if there is any such provision.
Like my lord will now come to section 2A, which is
Subsection 3 says permission to divert may be refused by the deputy commissioner. You please read that.
Lord, I'm with my lord's permission, I'll read that and then A. Subsection 3 is permission to divert may be refused by the deputy commissioner on the ground
that the diversion is likely to defeat the provision of any law for the time being enforced, or that it is likely to cause a public nuisance, or that it is not in the interest of general public, or that the occupant is unable or unwilling to comply with the conditions that may be imposed under subsection 4.
Yes.
Subsection 4 says, conditions may be imposed on diversion in order to secure the health, safety, and convenience, and in the case of land which is to be used as building sites or in order of addition to the dimensions, arrangements, accessibility of the sites are adequate for the health and convenience of occupiers or are suitable to the locality and do not contravene the provisions of any law relating to town and country planning. Erection of buildings.
Yes.
5. Where the deputy commissioner fails to inform the applicant of the decision.
That is not applicable. That is not applicable. So only 3 and 4.
Yes, now I got A. And there are a list of.
That is, if the formation of the layout has been carried out without obtaining permission.
That is right. Now, my lords, you may see the permission itself, which is that.
So on a plain reading of subsection 3 and 4, you will not be able to point out any provision that has been violated either by the deputy commissioner while granting the conversion order or at the hands of the applicant.
That my submission would be that the conditions that my lord sees in 2A, which are also reproduced in the permission granted, it says that.
2A will not be
No,
applicable.
no, what I'm pointing out, my lord, is the conditions that are granted in 2A.
So that provision is made in subsection 3 itself, that the deputy commissioner may impose conditions.
Yes.
All
Now,
right.
this is the conditions imposed.
Yes,
And this is where my objection flows from.
yes.
This, my lord, is our annexure K, page number 55.
Yes.
My lord will see after identifying that this page number 55 is in relation to the shopping complex that for which the conversion was being sought
Yes.
for 89 cents. Over on page number 56,
Yes.
the shut to agree. ಐದನೇ ಅಲ್ವಾ? ನೀರಿನ ಹತ್ತಿರದಲ್ಲಿ ಇರುವ ನದಿ, ಕಾಲುವೆ, ಹೊಳೆ, ತೋಡು ಇತ್ಯಾದಿಗಳಲ್ಲಿ ಹರಿಯುವ ನೀರಿನ ಸ್ವಾಭಾವಿಕ ಹರಿಯುವ
ಸ್ಥಿತಿಯನ್ನು
ಬದಲಾಯಿಸತಕ್ಕದ್ದಲ್ಲ.
Yes.
My submission, my lord, is when a condition is imposed that there cannot be any diversion of the natural flow of water. It is implicit that there is a confirmation that it is already not diverting the flow of water. Because permission cannot be granted. Because when an affidavit for conversion is granted, these are the conditions that the applicant says, I am not violating any.
Yes.
As on the date when the conversion was granted, there was already a complaint on the file of the district authorities that because of the raised level, the water is already being stopped. My lord will see that letter of May of 2019. So what flows from this is, before granting the permission, was any factual ascertainment done that this is actually not disturbing the flow of water? It is only after that that the petitioner will provide the product.
Sir, there are two things. Please understand. As you pointed out, there are two water courses on both sides of the property.
Please.
If this person did anything to stop the flow of the water running in that course, then they will be liable and you can say there is violation of the condition. Your submission that over the entire land water was flowing and therefore they should not be permitted to put up the compound, that submission cannot be accepted.
This actually came up, my lord.
Yes.
My lord.
Even without raising the ground level, they are permitted to put up the compound.
As long as it has.
If they put up the compound, what will happen?
That is, as long as, my lord, there is no disturbance to the natural, because it's one of the.
No, please understand, sir. This condition is pointing out to any natural course of water that is running, which cannot be tampered with. The flow of water should not be stopped. Now, please point out what action of the petitioner has violated this condition. He is saying, no, I am not both the water courses are there open. I have not touched it. On the other hand, it is the Gram Panchayat or the Zilla Panchayat which has put up a road. And you did not raise any objection at that point of time.
I appreciate it. This issue came up a lot when this petition was pending on the 12th of October 2020. When my lords directed that the Tehsildar will conduct a spot inspection.
Yes.
And in the presence of the parties, study the problem and file a report.
So maximum that can be done is in that other writ petition. You want that matter to be listed here, I can get it listed and I can consider that. If they have put up the road without following the due process of law, then it has to be removed. If that is removed, all this problem will be solved.
I am respecting that, but my lords will see that Tehsildar is now filed a report on my lord's directions. Actually reporting what is causing the obstruction of the. The lord may see that report. It is filed with IA number 1, annexure A. This has come pursuant to my lord's order. This is dated 3rd of November 2020.
Yeah.
A number 1, that is my application for petition. The first document at page number 23.
IA number 1 filed by whom? For vacating stay.
Document number 1.
IA number 1 of 2024. Yes.
First page number 22. The report of the Tehsildar pursuant to my lord's order of 12th of October. I will read the order and the Honorable Court has passed and then read the. 12th of October 2023, my lord said, the read the operative portion. Senior counsel appearing for the particular seats for passing of victim order, staying the order of the KP and submits the order. Financial. So the submitted that they have submits it. It is found necessary that the MS Kashar Tehsildar report carry out a spot inspection. The memo of instructions and evidence of both sides regarding the direction of the KAT, which reads as follows. The respondent number 1 is directed to ensure that obstructions of the said subject matter, the national flow of water, are immediately removed and the national drainage basin restored. The Tehsildar will make up the report regarding the said aspect. In the interim, the Tehsildar can also make suggestions to the parties concerned regarding the national flow of water and its obstructions, and the parties are at liberty to comply with the same. The matter is also parties to be present at the spot on 17th of October 2023 at 11:30 a.m. In the interim, there would be a sale or cancellation of the order of convert as ordered by the Karnataka. Applications numbers. It is also made clear that the present order is subject to further orders. In the interim, the petitioners are not created by types. The said undertaking is made in the presence of the petitioner. After the report of the test, the court reserves the liberty of passing of the orders. Any action taken by the petitioner, subject to the orders of this court, and of instructions by the court, the parties will.
Yes.
This is an order dated 3rd of November 2023. The first page of the order, Honorable Court's order is.
Yes.
On the next page, the second last paragraph. Findings are there. Suddenly, Hajarita Ila Gramastu Manchi Karanam Karanam. Survey number 35 number 2. Next, ನಂತರ ಸರ್ವೆ ನಂಬರ್ 35 ವ್ಯವಸಾಯ ಮತ್ತು ಸರ್ವೆ ನಂಬರ್ 35 ಕೂಡ ಪರಿವರ್ತಿತ ಜಮೀನಿನ ಮಧ್ಯೆ ತಡೆಗೋಡೆ ನಿರ್ಮಾಣ ಪ್ರಾರಂಭಿಸಿ ಅರ್ಹಕ್ಕೆ ನಿಂತಿರುವ ತಡೆಗೋಡೆ ಸ್ಥಳವನ್ನು ಪರಿಶೀಲಿಸಲಾಯಿತು. ತಡೆಗೋಡೆಯ ಪರಿಶೀಲನೆಗೆ 35 ಜಮೀನು ಮತ್ತು ಅದರ ಹಿಂದಿರುವ ಜಮೀನು ಪರಿವರ್ತಿತ ಜಮೀನಿನ ಮೂಲಕ ಮುಂದೆ ಹರಿಯಲು ಸಾಧ್ಯ ಆದರೆ ಸರ್ವೆ ನಂಬರ್ 35 ನೀರು ನಿಲ್ಲುವ ಸಾಧ್ಯತೆ ಇರುತ್ತದೆ. ಸರ್ವೆ ನಂಬರ್ 35 ಪರಿವರ್ತಿತ ಜಮೀನಿನಲ್ಲಿ ಹೆಚ್ಚಿನ ಮಣ್ಣು ಸುರಿದು ಈ ಪ್ರದೇಶದ ಭೂಮಿಯ ಮಟ್ಟವನ್ನು ಸಹ ಎತ್ತರಿಸುವ ಕಾರಣ ನೀರು ಸದಾ ಹರಿಯಲಿಕ್ಕೆ ಅಗತ್ಯ ಆಗುವ ಕಂಡುಬರುತ್ತದೆ.
This finding
Yes.
will be of no consequence because such a finding will be contrary to the provision. As I said, even without raising the level of the ground, if a compound wall is put, would it be in contravention of the provision?
But
Once compound wall is put, what will happen?
but even the compound wall when it is constructed, because all of this was contiguous agricultural land.
Right, sir.
Please,
But your contention that water used to flow throughout the land, and therefore the moment the ground level is raised or a retaining wall is put, it would stop the flow, and consequently all the water is retained in your land. That is your
yes.
so this finding will be of no consequence because they have a right to put up a compound wall. Will you agree that they have a right to put up a compound wall or not?
But I would submit most respectfully that they have a right to
Therefore,
demarcate their property.
All that the condition is pointing out is, if there is any water course, that should not be stopped.
Yes.
They have not done any such thing.
Lord, as in the what?
On the other hand, it is very clear that these panchayat has put up a road reducing the extent of that water flow. That has to be removed. That is the only thing that can be done. You cannot have a grouse against the petitioner saying they have raised the ground level and put up a retaining wall, and therefore it will be in violation of the conditions. There is no violation of the condition.
Lord, please consider this.
Yes.
Permission to convert was granted in the year 2021.
Yes.
In the year 2019, the property came to be purchased by the petitioner.
Yes.
Several years before that, there was already a grouse on the file of the district authorities that the natural flow of water is being obstructed for this very reason.
How?
Because of the mud that was put on the land. And
Yes.
this might also scare the part
At
of
that point of time,
Yes.
without obtaining a conversion order, if some person was doing something, that would be clearly in violation of the provision.
I most.
Now, once a conversion order is obtained, this person is entitled to put up a compound wall.
With the Lord's permission.
Once compound wall is put up,
My
you cannot have a grievance. No, the water was flowing everywhere, so they cannot put up a compound wall.
My submission, the Lord, is not that something has happened after the conversion.
No,
My
that's what I
submission-
said. If an activity which was prevented in law, putting mud and raising the ground level without there being an order of conversion or a permission secured at the hands of the revenue authorities, if that person was doing that activity, it will be in violation of the provision, therefore action could be taken.
That is right.
Now, after a conversion order is passed, if this person puts up a compound wall, what will happen?
What is the question for my lords? Is the
The
conversion?
maximum that can be done is to remove that road.
I have no objection.
That is all.
But one point.
Yes.
If the question is whether the conversion order itself was validly passed, the relevant factors would be those.
Therefore, I gave you an opportunity to point out which provision has been violated.
No, the very provision, the requirement that says that the national course of water cannot be changed.
They have not changed, sir. That is what is the finding.
May I show
Even having regard to the report submitted by the Tahsildar, how can he say that because the retaining wall is put up, it is stopping the free flow of water? What do you mean by free flow of water?
But the issue.
If there is any natural course of water, that cannot be tampered with.
Yes,
That is all.
What happens?
They have not done anything, sir, anything like that.
With the greatest respect. On the day when the conversion order was to be passed, the same issue at hand was already before the district authorities.
Yes.
The question that would have arisen before the respondent authorities in the exercise of granting the permission or denying the permission is to ascertain whether.
That is why I am asking you, you will have to point out from the provision of law that this is the provision which would have enabled the deputy commissioner to reject the application. Which is that provision?
Subsection 3.
Yes.
Permission to divert may be refused by the deputy commissioner on the ground that diversion is likely to affect the province of the timing influence, or that it is likely to cause a public nuisance, or that it is not in the interest of the general public, or the occupant is unable or unwilling to comply with the conditions and legally imposed under subsection 4.
Yes.
Now, my lord may consider this. As on the date when the conversion order is being passed, upon an inspection of the property, if the very same conclusions that we find did be existing and were existing even then, because problem is a long-standing one, the district commissioner, the deputy commissioner would have in his authority to impose a condition saying, if you are putting up a wall, ensure that this flow of water into the road, which is on the right hand side. I'm not talking of the one where there is the road, that also has to be taken care of. But the free flow of water into the drain on the right cannot be restricted.
It is not restricted.
Similarly, there could also, the deputy commissioner only on inspecting the property could also impose the condition that you cannot change the natural gradient of the land, that the water stops flowing downwards and accumulates on one land.
That is why I am saying, even without all that, this person is entitled to put up a compound wall. What will you do?
The only thing.
If a compound wall is put up, it will naturally stop the flow of water according to you.
Not necessarily, my lord.
Then
Because a condition can be imposed that necessary engineering advice will be taken that the compound wall does not stop the water.
what can be done?
My lord, it has to be only in an angle so that the water leads onto the road. Right now it is blocked. It is not flowing.
No.
My lord,
Water, even if it is flowing like that, it will go across the wall and join the stream.
my lord, just have the photo because I have put this photography.
Yes.
My lord, it's a page number 36 of I number 1. My lord, just have it for one. Page 36.
Yes.
I'll show some of the photos that were on file. Then my lords get an idea as to how the gradient is being disturbed. Document number 2 starting at page 20.
Yes.
The picture on the top, my lord, is the aerial view of the property, how it was.
Yes.
The picture at the bottom is now when the mud was put. This is as from February of 2023. Number 29.
29.
Page number 29, document number 2, I number 1 of 22. This is when, for many years, this was the state of the land. At the bottom of the page has been 6/2/2023. This is the petitioner's land. Now mud has been put, but my lord, see, there is a nala there. So earlier water used to come in there. When you see it next to the property.
Not the nala, that's.
I will show. There are multiple.
This is towards the state highway,
Yes, between the state.
not abutting your property.
Yes, this goes all through or along the neck. Page number 30. My lord will see that may the water takes the route of this, flows under the state highway and joins.
Correct.
Page number 31.
This is a state highway,
Yes,
abutting the land of the petition.
yes.
And what we see that at towards the end, the Kerala Bharati Road, near the car, that place which was open for the water to flow is still there. Page number 32. To the showing the state of the property now after the leveling has been done. So now the gradient is gone. 8 feet of mud has been put. Now it is flat land there. Everywhere else it is sloping for almost hundreds of acres. Now my lord's comes to page 33. So this is what is happening because the retaining wall and the situation is helpless. With the wall here, the flow which would have gone through the land, through the Nala, is now on page number 33 as my lord says on June 20, July 23rd, 2023, is completely inundated by land. Page number 24, my lord, see this is during the rains what happens. It cannot be recognized as a land. It is fully water inundated. And this was not happening before. It was the moment without considering these factors, permission is given in a blanket manner, saying that, my lord, this we can conceive of a situation.
Again and again, I'm asking you, what kind of a condition could be imposed by the deputy commissioner?
That when a wall is, if a wall were to be constructed, it will be constructed in a manner so that the water will flow along the wall into the drain. But now what has happened? The wall has stopped the water. Now please see page 36. This
outland and slope ಮಾಡ್ಲಿ outland ನಾನ್ ಮಾಡ್ಕೊಡ್ಬೇಕು.
slope already there. Right? But the slope continuing because artificially what has changed, my lord? Artificially it has changed with the petitioner's land. Please see page 36. This is the situation. There is a wall, there is leveling of mud, and that's it is completely water inundated. I am showing pictures during the rainy season for particular reason. 3 to 4 months in the year, my land is completely inundated with all the water, not from my land. From almost hundreds of acres, it is slopey land. It is all collecting.
Therefore, the maximum that can be done is to ensure that the two drains on both the sides are kept open, made clear, to ensure that there is a clear flow of water.
Yes, but I would,
And that action has not been done by the petitioner. It has been done by the Gram Panchayat.
I would most respectfully submit, my grounds will be with both the Gram Panchayat if that road is blocking it and with the petitioner if the mud leveling is stopping the water.
Even without raising the level, they are entitled to put up a compound wall that cannot be prevented.
If there is a fencing, my lord, all I would.
Why? No. That's what I'm saying. When once a conversion order is issued, is he not entitled to put up a compound wall?
That is exactly my contention, Lord, that the point at which this consideration is given is at a time before the conversion is done. Could the deputy commissioner have, without considering all these aspects, after the conversion order, my respectful submission would be no. Because the deputy commissioner would.
There is no such provision that would prevent the deputy commissioner.
No, there is.
All that is found is in subsection 3.
Yes, sir.
All that it says only regarding public nuisance.
Yes. This is for, my lord, the farmers are.
It is only you, sir.
No, my lord, I am two among.
It cannot be done only for your benefit.
My lord,
Anyway, we will, the best that can be done, we will try and do it. Not beyond that. You can't say, no, they can't put up a compound wall also.
My lord, my
Not
submission
possible.
is this. If the compound wall also, with advice taken from structural civil engineers, can be made in a way with just enough inlets that the water continues to.
So water starts flowing everywhere throughout the property of this person. Not possible, sir.
My humble submission is this. If all these years, there was a natural course of water that took the rainwater.
That is why natural course means what?
Because
Not the entire water flowing on the entire land, sir. That is not possible. That is not the meaning.
that's not,
So the two water courses are there which on the both ends of the property. It is only that.
yes,
It can be referable only to that.
I agree, but what would fall within the scope of consideration is fine because the water is not directly falling into the nalas. The land is
From every land, water that flows into every land, including your land or their land, water will flow towards the nala. That is how it has to be drained out. You can't have a contention No, water has to flow through this property only. That cannot be accepted.
Let it be like this.
Yes.
I obviously would have no objection to anything. Let us say despite the mud, despite the wall, the water was still flowing into the nalas. I obviously will have no grievance.
Correct.
My grievance is because the nalas and the road has been put out, laid down in a particular way for over decades now. So that people are considering the natural gradient of the land, the water will eventually flow into the nalas.
Yes.
What has happened today? And I am limiting my submission to whatever has happened at the point of granting the conversion order. The deputy commissioner and the district authorities who are already considering this issue with the predecessor directive has not even looked into this aspect by imposing a condition saying that you will not impact the natural flow of water, have not ascertained.
They have imposed that condition. You are yourself read it out now.
Submitting is, if a condition has been imposed, saying in the future this will not happen, it implies in it a satisfaction that today it is not blocking the flow of water. That ascertainment has not been done, and that is why the KT found that how can a conversion order be granted unless the deputy commissioner goes there, conducts an inspection, and at least gives an opportunity to the person who is being impacted by it, because they are not unaware of this. They already have my complaint for the last 5 years. How can a unilateral permission be granted at the cost of all the water now settling on one piece of land, not going to the Nala now? Because of 3 factors, let's take it as 3 factors. A road on the left put up by the Gram Panchayat, a wall that has been unilaterally put up by the petitioner, and raising of the level artificially by almost 8 feet that the water is stopped there. I have not been able to conduct any agricultural activity for the second season of sowing in the last 5 years. This may not, so a conversion order can be modified in a manner that the wall, if it is to continue to exist, can have inlets. The gradient of the land, obviously, they put 8 feet of mud. If the deputy commissioner were to examine it, a condition will be put that this slant will be maintained so that the water continues to flow. What is happening is for hundreds of acres, the land is like this, and it suddenly becomes flat. It is natural that the flow will stop and all the water will accumulate here. My land literally resembles a lake around in the rainy season. I can't conduct any agricultural activities there. And I am a small farmer. There's only so much I can do, and I rely on the natural drainage system for this to happen. So the summits.
Once about that flow to what we expected. Entire problem started because the previous sector did not sell this land to them. That's the only issue.
I am a farmer. So my submission is this aspect has to be considered. And if my lords were to suggest that let the deputy commissioner revisit this order that has been passed after considering this aspect of the natural.
And do what?
Solutions can be ingrained into the permission itself.
Conditions are already imposed, sir.
Condition is
Say that they will not tamper with the water course. They have not done anything.
Not today, the 3 factors that are responsible for the water course being stopped. By water course, I am referring to the flow of water into the tollways. Are one, the Gram Panchayat's road, as the.
That's why I said you didn't raise an objection when they were putting up the road.
When the road was being put up, even today, my case is that most of the water that goes to the larger road, because there are 2 roads. One is a small one. If that is also cleared up under my lord's order, it is only my relative. But today, my submission.
That is the maximum that can be done, nothing more.
Lord will consider.
Yes.
Well, Lord, please consider. This aspect has not, there is no finding, there is no recorded, there is no opportunity given to me before a unilateral permission is given without any conditions being imposed, and I am bearing the brunt.
The conditions are imposed, sir. That is the maximum that the deputy commissioner could do.
The Lord, the deputy commissioner.
He cannot impose conditions as he wants. That is not possible.
I would submit this. I am not suggesting this should be the condition.
Yes.
But the deputy commissioner, had he only conducted this inspection, my grouse that is not even conducted that inspection. As of 2021, my lord.
All right.
My lords will find that there is not a single official record that is looked into this.
All right. After that, what?
Therefore, my lords, if this problem is considered even today, and a solution can be even suggested, that the natural flow of water, any activity, either activity that I conduct or activity that the petitioner conducts, in order to conceive of a scenario where today I put up a wall at the end of my land. The natural impact, I'm just saying what will happen. All the water will stay up in my neighbor's land. This, my lord, is a never-ending problem then for all the farmers.
Therefore,
That can be done.
therefore, the authority can only impose conditions that are permissible in law. He cannot do just because you have raised an objection even earlier, but that objection was sustainable because this person was doing something without taking permission. Now, permission has been taken.
Not considering the same factors.
What
My lord, if
conditions have been imposed which are permissible in law? He cannot impose a condition that you don't put up a compound wall.
absolutely
Then
not, I'm suggesting,
once a compound wall is put up, then again the same problem.
let me suggest this.
Yes.
My lord, what can the deputy commissioner have said? I'm just taking it on a dimmer. Can the deputy commissioner, let us say he had visited and found that this is the exact problem that will arise if he grants the permission. Could he have granted a unilateral permission saying, I give you a blanket permission, do what you want on your property, even if it crosses flooding territory? My humble submission is that could conceivably not have been the nature of a conversion order that could have been passed. Therefore, the question arises, what ought the deputy commissioner to have done? Which is what the KAT identifies, saying that the least that ought to have been done is that examine the situation on ground and any permission to either grant it or to deny must be on the basis of the scenario that is being faced there. Undisputedly, the scenario is that water is, for the good or the bad, flowing to several agricultural lands to finally reach the road. Today, the only intervening factor along with the road is the raising of the land to defeat the inundation, defeat the gradient of the land and putting up of a wall. If these are the only things that have resulted in the situation that my lord have before the court today, can the conversion order stand in the same way? It has to be with a further condition at least that necessary steps will be taken to ensure that even the mud can be made a gradient. The wall will have inlets so that the water continues.
What about the compound wall?
No, they can have what compound wall still have inlets. Let us say a 9 feet wall. 2 feet if there is an inlet. That is a condition that can be imposed.
Why should they do it?
My lord, because I am suffering.
It's not because of that. Please understand. That is why I am saying it cannot be only because of an individual interest.
I'm
The
not.
provision says if there is a public nuisance and the water course is stopped, it will be a public nuisance and therefore such condition has already been imposed. They have not done anything to stop the natural water course that is running on both the ends.
Assumption would be that the raising of the land.
That cannot be. You can only request them if they want to do it, they can do it. Otherwise, no. Not as a matter of right.
I'm not suggesting it as a matter of.
You should have had a better relationship with them.
I'm still attempting, my lord. In fact, after my learned senior has come up, we even had the opportunity to have this inspection done. But the situation still remains. That we are now operating.
That is all the maximum that can be done. Is that other repetition?
Number. 21368 of 2023. Can you write along with this?
Heard. Senior counsel Sri K.N. Panindra on behalf of the petitioner and learned counsel Sri Vikas Mahendra, Aditya Chatterjee for response number 3 and 4. So, it is brought to the notice of this court that another petition in WP number 21368 of 2023 relating to the same subject is pending consideration for this court. So, although it is classified as local bodies matter, it pertains to the concrete road said to have been put up by the panchayat. So, release this matter on 19th of February 2024 along with WP number so and so. At 2:30 PM. All right, 20th, 2:30. Yes. 21st, all right. Aye, 21st, 2:30. Ajit. Adralle, office is directed to show the name of learned counsel for response number 5 and 6 as Ajit Achappa. Yes. You have to take steps for respond number 8.
Sequence to that order, the Karnataka has located the revenue entries. They will not respond number. This is the only question. You actually kindly direct the Karnataka to keep the location entries as it was on the as on the date of the passing of the deputy commissioner. Appear before the Karnataka and in this stage, there is already a stay order granted from the sort of. So your Washington kindly direct us to appear before the Tahsildar as per the order of deputy commissioner, but my only endeavor is that connection law is changed, limitation limits are changed subsequent to this remand are pretty. I said few matters. Page 75. Operating portion is at page 82. The operating portion only says that mainly in partnership administration, after that, more than 32 plus 30. More than 66 article press release. Yamanas are performing in the position is equal to the this was done on 15/10/2023. The very next page, page number 83 is the notation order.
So your name was entered consequent to the orders passed by the assistant commissioner. Then
Consequent to the orders passed by the Tahsildar, my name was entered. That
when,
order was challenged before the assistant commissioner.
when was the order passed by the Tahsildar?
That's
17/2023. That cannot be restored. That cannot be restored.
My only submission is that
Your name was entered only after order was passed on 17/2/2023. Huh?
That was all of the deputy commissioner. The name of the respondent of private seats have been located in the revenue records. With respect to the revenue entries is concerned, this is the target criteria not of state. With respect to the revenue entries. You are on the debate.
The entire issue is only regarding revenue entry. Nothing else here.
Based on the decision set, we are claiming over. Based on the decision set, respondent of private seats, claiming trade for the property.
When did you get the property registered?
Then 5/2006.
2006. Then mutation entry was made when? ಅದನ್ನ 2023 ಅಲ್ಲಿ ಬಿಫೋರ್ 2005 ಕರೆಕ್ಟ್. ಆದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಏನಾಯ್ತು, ಆಫ್ಟರ್ that 2005-2006 mutation entry has been set aside by order dated 17/2/2023. Thereafter, your name has been entered. Isn't it? Huh?
I made a representation to the applicant authority on 14/1/2020. Seeking occupancy.
Correct.
Subsequently, that
Tahsildar has passed the order on 17/2/2023. Thereafter, your name has been entered.
earlier, my kindly take action here. At least my name was reflected. Yeah.
Huh?
Annexure here. It's 35. Page 32, 6 and 37. These are not my kindly take page 37.
ಅದು ಬಹಳ ಹಿಂದಲ್ಲಿ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ನೀವು. There is no doubt, no quarrel about that. But his name was entered in the year 2004-2005. Huh? That order has been set aside only in the year 2023, February 2023. ಆಗಿರ್ಬೋದು.
In that petition, Central Court used to observe that there were several sale deeds.
Yes,
And the Tahsildar was directed to inquire into the matter and pass appropriate order.
yes,
That order, the Tahsildar has passed the order in favor of the petition.
correct. That was only in February 2023.
Yes.
That cannot be restored now. Let him consider the directions and accordingly the revenue entries will be made. See, if there is disputed questions of title, even the Tahsildar or the Deputy Commissioner cannot decide. In fact, there was no need of remanding the matter. We should have directed you to approach the civil court.
Occupancy rates was made in the year 1981.
Ah.
From then, my last only 5 acres we granted in favor of the Central Court. Another 5 acres we granted.
See, there is a disputed question of title now. He is claiming under a registered sale deed. You are saying that sale deed could not have been executed. So therefore, who is going to decide this? Revenue authorities? Then please go before the civil court. It's no use going before the Tahsildar also. Okay. The petitioner is aggrieved of the impugned order dated 5/10/2023 passed by the Deputy Commissioner, Shimoga District. So, next para. Where is that order of the Tahsildar? Annexure M. The petitioner Mata, petitioner Mutt filed an appeal. Petitioned the Tahsildar, Shimoga Taluk. With regard to the revenue entries in respect of 3 acres 20 guntas in survey number 133/1, 32 guntas in survey number 133/2 and 31 guntas in survey number 133/6. Full stop. The revenue entries were mutated in favor of respondents number 5 and 6 in terms of MR number 2005-6.
One more showing of page 16.
Dated 10/5/2006. Full stop. The mutation entry was made in favor of response number 5 and 6 on the strength of a registered sale deed dated 9/6/2007. Full stop. However, it was contended by the petitioner before the Tahsildar that occupancy rates were conferred in favor of the petitioner Mutt by orders of the special deputy commissioner in the proceedings taken up under the provisions of ಯಾವುದು ಅಲ್ಲ ರೀ ಆ ಇನಾಮ್ಸ್ ಯಾವ್ದು ಯಾವ ಇನಾಮ್ಸ್ ಅಬಾಲಿಷನ್ Huh? (1954) ನೋಡ್ರಿ ಯಾವ್ದು ಅಂತ ಮೈಸೂರ್ ಬ್ರಾಕೆಟ್ ಅಲ್ಲಿ ಪರ್ಸನಲ್ ಅಂಡ್ ಮಿಸ್ಲೇನಿಯಸ್ ಕ್ಲೋಸ್ ಇನಾಮ್ಸ್ ಅಬಾಲಿಷನ್ ಆಕ್ಟ್ 1954. ಯಾರು ಸೂಟ್ ಫೈಲ್ ಮಾಡಿರೋದು 169 of 2013. ಕಾಳಿಂಗಪ್ಪ ಬಿನ್ ಮಾಳಿಗೆ ಹನುಮಂತಪ್ಪ, ಅದೇ ಪೇಜ್ ನಂಬರ್ 68 ಅಲ್ಲೇ ಇದೆ. ಆರ್ಡರ್ ದಿ ತಹಸೀಲ್ದಾರ್ OS number 169 of 2013 dated 7/1/2020. The Tahsildar has also referred to a judgment passed in OS number 169 of 2013 dated 7/1/2020. Stop. The Tahsildar accepted the contention of the petitioner Mutt and consequently set aside the revenue entries made in favor of response number 5 and 6 herein. Full stop. Aggrieved. Response number 5 and 6. Approached the assistant commissioner. Where is that order? 70. The assistant commissioner remanded the matter back to the Tahsildar for fresh inquiry and to pass appropriate orders, by his order dated 6/6/2023. Stop. Response number 5 and 6 approached the deputy commissioner, calling in question the orders passed by the assistant commissioner. Stop. The deputy commissioner has passed the impugned order
Respondent number 5 and 6 approach the deputy commissioner calling in question the order passed by the assistant commissioner. Full stop. The deputy commissioner has passed the impugned order.
While noticing that there were several sale deeds executed in respect of the land in question, and the land was converted from agricultural to non-agricultural purposes, and sites have been formed. Stop. The deputy commissioner is of the opinion that the Tahsildar had given sufficient opportunity to all the parties concerned, and thereafter had passed the orders. The deputy commissioner allowed the revision petition in part set aside the orders passed by the Tahsildar on 17/2/2023 and the order of the Assistant Commissioner dated 6/6/2023, and thereafter remanded the matter back to the Tahsildar for fresh consideration. Stop. Next para. In the considered opinion of this court, it is evident from the contentions raised by the rival parties herein that there are disputed questions of title. Full stop. That being the position, comma, the deputy commissioner would not have directed the Tahsildar to reconsider the matter. Full stop. It is by now well settled and reiterated at the hands of the full bench of this court in the case of Srimati Jayamma versus State of Karnataka and others, reported in so and so, that ILR 2020 Karnataka 1449, that the revenue authorities have no jurisdiction to decide the title dispute between the parties in respect of immovable properties. Stop. It is the exclusive domain of the competent civil court to adjudicate the disputed questions of title. And ultimately, if a decree is passed by a competent civil court, then the same shall be binding not only on the parties but also on the revenue authorities. Full stop. Next para. In that view of the matter, this court proceeds to set aside the impugned orders passed by the deputy commissioner in RA number 20 of 2023, and also the orders of the Tahsildar as well as the assistant commissioner. Stop. The aggrieved party has to approach the competent civil court, secure a declaration and once such a declaration is given by the civil court, such party will have a right to seek entry of his or her name in the land records. Full stop. Ordered accordingly.
Number one. Isn't cut. If. And then.
Huh? Finally, a week's time is granted. At the request of learned counsel for petitioner to take steps for service of notice on respond number 3.
Number two, Chandra B.
Same order in respect of response number 3 to 13.
Number three, Big Kumar R.
Same order in respect of response number 3 to 28.
Number four, Jagdisha P.
Same order in respect of response number 4.
Number five, Nagendrayan.
A week's time for response number 7 to take steps. Yes.
Number six, Dish Kumar Acharya.
Respect of response number 3 and 4. Yes. Yeah. Okay. Okay.
Number 45. Mr. Narendra B. Goda. Fine.
On 6/2/2024, the following order was passed. Extract monthly. Next para. Matter is called out. There is no representation for the petitioners. So steps have not been taken to serve many of the respondents. Although sufficient opportunity has been given to the petitioner. Full stop. Consequently, the writ petition stands dismissed for non-prosecution.
Interpret application, serial number 24. What is it? Lot of 53.
Huh? Petitioner number 3. Orders on IA number 1 to 3 of 2024. These applications are filed by the legal heirs of petitioner number 3 seeking to come on record on the demise of petitioner number 3 on 19/6/2021. Full stop. There's a delay of 28 days in filing the application. Full stop. This court is satisfied with the explanation offered for condonation of delay. Full stop. Consequently, delay is condoned, abatement is set aside, and the applications are allowed while permitting the legal representatives of petition number 3 to come on record. Full stop. Next para. Learned counsel for the petitioner shall carry out the amendment in the cost title and furnish amended cost title within a period of 1 week from today. Yes. Huh?
Notice issued under 108A, nothing question is proceedings. On 3 grounds. Firstly,
Notice.
108A. Page 14 of prior directives. On 2 grounds, they called it a question of grant that was made in 2011. This is questioned in 2015, 3 years after the grant. And since there is no reasonable time to exercise, they will exercise a revisional power, suo motu. And that was not for the fault of petitioner. From the very reading of the notice, it is evident to the fault in the revenue side. And it's clear of the revenue.
Yes.
Last 3 lines. But the usually everybody Kari Germany into usually ಬಗ್ಗೆ ಕಂದಾಯ ಪದವಿ ವರದಿ ಇರುವುದಿಲ್ಲ. ಹಾಗೂ ನಮೂನೆ 53ರಲ್ಲಿ ಇಲ್ಲದಿರುವುದು ಕರ್ನಾಟಕ ಭೂ ಕಂದಾಯ ಕಾಯ್ದೆ ಸೋಯಿಸೋ ಭೂ ಕಂದಾಯ ಅಧಿನಿಯಮ ನಿಯಮ 108 ರಲ್ಲಿ 1/10/2000 ಪುರಾಣ 11 ಗಂಟೆಗೆ ವಿಚಾರಣೆ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ವಹಿಸಿದೆ. He is submitting that he has not found it in his record. He is not saying that the petitioner has not submitted form 53. It is not found in his record 3 years after the grant is made.
No, that's all right. But the other portion of it that you are holding.
That was my own submission which I had made in 1986, 84, 85. Saying this is a joint family property. That is covered by law by Chandra.
Therefore, without even giving an opportunity,
There's one more thing that has happened. Next year,
you have to go. Please go make all these contentions before the assistant commissioner. Let him consider and pass order.
By approach, I must take up page 17 of the petition. The assistant commissioner has not passed any orders. What happens when the Tahsildar
Was there a order of stay here?
an order of state? The assistant commissioner does not pass any orders. Then the Tahsildar says, I will initiate proceedings and criminal proceedings for encroachment on government time. The stand is already granted to me. Even before the assistant commissioner can pass an order, the Tahsildar takes these steps to evict me from the property. And now at page 9 of the petition, I specifically about what has happened. Page 7 and also time.
No, we will protect you. We will protect you till orders are passed by the assistant commissioner. They cannot do anything during the pendency of the appeal before the assistant commissioner.
Contention. If form number 53 is not found in their file, I cannot be held responsible. 1994 I submitted. In 2015, after the grant is given, after 3 years, they can't come and say it is missing in my file. It is not their contention that I have not filed it. He is saying it is missing in their file. And why it is missing also, for that also I produce a paper, paper report that has come. Subsequent to the grant that was made in 2011, in 2015, one more committee was formed to regularize unorganized occupation. What they do is, whatever grants were made in 2011, they take the same files, remove all the form 53, enter new names, and then grant it to them. That paper report is also at page 86.
Similar allegations were made and we have passed orders. Either Madkeri idena? Madkeri ide. Then same orders will have to pass. Other. Yes. Was any inquiry directed to be initiated by the Lokayukta or Uplokayukta or someone?
What I have done, charge sheet has.
Because in that matter, I think they had seized the records. Similar allegations were made. They had seized the records.
Records have been seized. In fact, I approached the investigation officer and said, give me a certified copy of the order just to see if my entries are there.
The investigation officer said records have been destroyed. Our only aim is to find out who has, which revenue officer has been done it. What happens to the agreed person is not my concern, is what they have said. So in this condition, my lords, now I am not able to take my grant order can't be passed because the revenue officer has done something which is not very, I am not the beneficiary of his wrongdoing. Because this has happened in 2017. I was granted this in 2011.
No, it cannot be that orders have been passed by the committee without even, see, the process is that the Tahsildar will place the application before the committee along with his recommendation. Then how can he say, no, there was no application itself?
I have produced everything before my lords from 1984 onwards. When I have paid 30,000 for the streets that were there, way back 1985 itself.
Huh?
My file number is NCR 2 of 1984-85. Representations were made back then. In 1985 itself, the Forest Department surveyed this land granted, subject to payment of 30,000. That was also paid way back in 1986 itself. Page 37 was the recommendation of the forest. Page 37 reserve.
What is this?
Department's recommendation. Saying this land can be granted with it. But Tahsildar had sought a report from the forest department.
If all this has happened, then how can they now say, no, there was no application? So we will say nothing regarding the whether the application was there or not. Not for that purpose. Only to find out whether he was holding excess land as on the date of grant, as on the date of application. Only to that extent. They cannot go into the question of whether the application was there or not, because there are enough material. Berkeley.
The checklist that they have prepared in 1994 after submission of form.
The petitioner is aggrieved of the impugned notice dated 1/9/2015 at Annexure A issued by the Assistant Commissioner, Madikeri Subdivision, calling upon the petitioner to appear for consideration of an appeal filed at the hands of the Tahsildar. ಇಲ್ಲ ಸರ್ಕಾರ ಅಂತ ಬರೆದ್ರೆ ಅದೇನೆ ಅವರು ಒಂದು ರಿಪೋರ್ಟ್ ಹಾಕಿರ್ತಾರೆ. In terms of rule 108(k) of the Karnataka Land Revenue Rules, 1964. Next para. Learned counsel for the petitioner submits that a plain reading of the impugned order clearly shows that it is now sought to be contended at the hands of the Tahsildar and the Assistant Commissioner that the petitioner was already holding lands to an extent of 2.50 acres. And therefore, the petitioner could not have been granted lands under the provisions of Section 94(A) of the Karnataka Land Revenue Act, 1964. So, the other ground seems to be that in their records, form number 53, said to have been filed by the petitioner, is not forthcoming. So, learned counsel submits that there are enough material on record to show that the application filed by the petitioner was assigned a particular number. Another?
Application number, file number was 2 of 8586.
File number 2 of
1985-86.
1985-86. Full stop. A checklist was prepared by the Tahsildar and a report was sought at the hands of the forest department and the range forest officer had given a written information as would be found at Annexure F dated 24/6/1986. Giving a reply to all the queries that were raised by the Tahsildar. Full stop. The range forest officer had opined that there can be no objection from the side of the forest department for granting the land in favor of the petitioner. Full stop. That being the position, comma, it would be impermissible for the assistant commissioner to now say that there are no records to show that the petitioner had filed application in form number 53. Full stop. The learned counsel would further submit that the petitioner himself had stated in his application that he was holding, his family was holding 2.50 acres of land, and that is not an information that is newly placed before the assistant commissioner. Full stop. In that view of the matter, comma, the learned counsel would submit that the assistant commissioner could not have issued the imputed notice to consider an appeal under section under Rule 108K of the rules, calling in question a grant that was made. Yavaga? On 5/4/2011. Full stop. Next para. For contra, learned AGA would submit that normally this court will not entertain a writ petition under Article 226 of the Constitution of India as regards a notice issued by the statutory authority. Full stop. Next para. Having regard to the submissions made by the learned counsel for the petitioner and the learned AGA, comma, this court is of the considered opinion that the contention of the petitioner can be accepted to some extent. Full stop. The material placed on record clearly goes to show that an application was indeed filed at the hands of the petitioner, and there are several transactions and communications which would clearly indicate that the respondents cannot now turn back and say it is questionable or doubtful as to whether the petitioner had filed an application in form number 53. Stop. To that extent, the contention of the learned counsel for petitioner is upheld. Full stop. However, insofar as the allegation that the petitioner was holding 2.50 acres of land and therefore he was not entitled for regularization of unauthorized occupation is something that the assistant commissioner may reconsider. Full stop. That's what. Only to that extent we are permitting the assistant commissioner to go into the question, verify, and thereafter pass orders. In this regard, the petitioner seems to have sufficient material to show that It was the family of the petitioner which was holding 2.50 acres of land at the time when the application was filed by the petitioner. Full stop. Therefore, the contention of the petitioner that he was still entitled to seek regularization of unauthorized occupation of 4 acres and 88 cents may have to be considered by the assistant commissioner. Full stop. Next para. Consequently, the writ petition is partly allowed. Full stop. The assistant commissioner, Madikeri subdivision shall proceed to hear the petitioner only in the matter of whether the petitioner was entitled to seek regularization of unauthorized occupation, having regard to the fact that the family of the petitioner was holding 2.50 acres of land at the time when the application was filed by the petitioner. Full stop. All contentions in that regard shall be kept open. Full stop. However, it is made clear that the assistant commissioner shall not go into the question as to whether the petitioner had indeed filed an application in form number 53, since sufficient material is already placed by the petitioner on record, which would clearly show that he had indeed filed an application in form number 53. Full stop. Next para. In the above terms, the writ petition stands disposed of.
Proceedings were pending before the assistant commission. The task force also issued another notice. It said so. The petition.
Needless to observe that till the conclusion of the proceedings at the hands of the assistant commissioner, the Tahsildar shall not proceed any further in terms of annexure B. Full stop. Annexure B, dated 10/2/2020, issued by the Tahsildar, Biraspet Taluk, is also quashed and set aside. All other matters next week. No dates. I am not giving dates in any matter. It will come up. All matters that have not reached today will come up next week.
New matter. What is their decision today? More end of the list are 3 times more.
Noted. Interim order actually extend then bekila because previous order is there. It will be extended till next date appearing. There is no difficulty. Yadu date kodalla. No dates. It will come up next week.